Any mention?
Please, Your Lordship, I beg to mention item number 1.
Number 1 of?
Admission hearing, Your Lordship.
Mention when it comes up. Don't mention, only hearing matters to be mentioned. But you're a veteran, how come you're doing that? Yes.
Your Lordship, I beg to mention item 19.
Number?
From the 19. 19.
1?
19. We pray for 2 weeks' time, Your Lordship.
1 second.
No objection, Your Lordship.
2 weeks.
Yes, Your Lordship.
2 weeks, yes. Yes.
Similar prayer to item number 24, Your Lordship.
Why is senior not available?
No, Your Lordship, he's not keeping well.
Yes, 2 weeks, yes.
No objection, Your Lordship.
Come forward. Yes.
We see 2 weeks' time, Your Lordship. 2 weeks' time, we pray. Much obliged, Your Lordship.
Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 18, Your Lordship. The conducting counsel
Number?
is 18. Conducting counsel is not available today, Your Lordship.
What number 18 who's conducting counsel?
Mr. SN, Your Lordship.
Otherwise, this matter will finish it off. What's the matter about? Service matter?
Yes, Your Lordship.
After 1 week.
Obliged, Your Lordship.
You're for the petitioner?
Lordship, I am for item number 29. I'd like to mention.
Okay. Who's for the petitioner?
Your Lordship.
1 week?
Obliged, Lordship.
Yes.
Item number 29, Your Lordship, the conducting counsel is from Guwahati, so he could not come to this. So 3 weeks time.
No excuse for conducting out of Guwahati.
Actually, I'm just.
What made it clear yesterday also.
Item number 1, Lordship, I'm appearing.
My Lord, in 19, in 29, which
Number?
my friend is mentioning, my Lord.
29.
29, my Lord. Anamika Datta. Mr. Sen is appear. 29, my Lord. Mr. Sen is also indisposed, my Lord. So he have also requested if this matter can be taken.
How long? 2 weeks?
3 weeks, Your Lord.
3 weeks,
Lordship.
okay. 3 weeks, yes. Yes.
May, Your Lordship.
Yes. Yes.
Lordship, I beg to mention item number 16 of today's daily list. Conducting counsel B. Pathak is not in town, India.
Where's Mr. Dr. Mozika?
16 and 17 are connected, madam. 16 and 17 are connected.
So you will take it after when? When is he coming back?
Lordship, after 1 week.
Okay, 1 week, 16, 17, yes. Conduct counsel Mr. P. Pathak's out of the country, yes.
Obliged, Lordship.
Your Lordship, I beg to mention item number 21. Kindly let this matter come after 2 weeks.
This matter was substantially heard, but they're supposed to come up with some more material.
Who?
Mr. Ravi Guru.
Why are you joining it? Mr. Guru is here. Why you not join it? When the matter is heard, again have you got a
I'm
fresh
here to come up with some.
authorities?
My Lord, yes.
1 week,
I've got
okay.
some people. Yes, yes.
Yes.
Please, Your Lordship. My Lord, beg to mention item number 23. My Lord, this is a first appeal, my Lord. Here, learned friend has not filed a paper book. Of course, paper book is not required, my Lord, but while preparing the matter, my Lord, certain documents I'll have to apply from the registry, the lower court records.
Why people have been made?
It's not actually required.
Last time you said not required.
Not
correct?
required, my Lord. Not required, my Lord. While preparing, my Lord, I had applied for some copies from the registry, my Lord, from the registry. But some documents are not with me. I'm just asking for a week's time, my Lord. I just need to peruse certain documents. That's all, my Lord. Just a week's time.
As prayed by Mr. KCH, who to enable him to obtain some necessary documents. This matter for 2 weeks, yes.
Obliged, Lord.
Yes. Yes, Mr. Rakhar, what do you want?
Also, I'd like to mention item number 20.
Memory link law.
Lordship. Also, I'm praying for 2 weeks' time. Lordship.
Why?
Lordship, actually, this matter, Lordship, settlement is going on, Lordship.
Correct.
My Lord, that is what I have also been informed.
Okay, after 2 weeks, yes, as talks of settlement are going on.
Deeply obliged, Lordship.
Yes.
May I please, Your Lordship? I beg to mention item number 32, Your Lordship. The conducting counsel is from Guwahati, Your Lordship. I humbly pray for 2 weeks' time, Your Lordship.
Lord, I'm appearing for the state in this matter.
No excuse for Guwahati counsel.
Your Lordship, he is unavailable today, Your Lordship.
And my Lord, this matter has
32.
already been
Yes, Your Lordship,
substantially
32.
Where's Mr. Hassan?
He didn't come, Your Lordship, today.
Who's the consul from Guwahati? I don't see any.
As Islam, Your Lordship.
SK Hassan from Guwahati?
No, Your Lordship. The conducting council is as Islam, Your Lordship.
Yes.
No
I humbly
excuse.
pray, Your Lordship, 2 weeks' time may be granted, Your Lordship.
I'm for the private hospitals.
Take 3 weeks
Your Lordship.
so he
Highly-
can prepare himself. Yes.
Highly appreciated.
Lordship, I beg to mention item number 25 Lordship, of the main list. Respondent,
All the list is gone. Yes.
Lordship, it's kindly.
You're for the. Who's for the petition? Inform them.
We have informed Lordship the petitioner.
1 week or 2 weeks?
Lordship, 1 week.
Okay, 1 week, yes.
Highly appreciated.
Please, Your Lordship. Lordship, I beg to mention item number 31, Your Lordship.
Number?
31.
Sapin Burman.
Yes, Your Lordship.
1 week, okay.
Highly Lordship.
Please, Your Lordship, I beg
Yes.
to mention number 28, Your Lordship.
28.
I'm free for 2 weeks' time, Your Lordship.
For?
For petitioner.
Where's your. Have you informed them?
We have informed them.
Okay, 2 weeks, yes.
2 weeks.
Yes.
Supplementary list, item number 1.
My Lord, I'm appearing for the petitioner in item number 1, Lordship.
Yes.
My Lord, this is an application, my Lord, where I'm praying for expeditious disposal, my Lord, of an application, my Lord, under section 38 of the Special Marriage Act, which I had filed on behalf of the father before the Court of the Learned District and Sessions Judge at Shillong, Lordship.
Why expeditious disposal? How long has the suit been pending?
My Lord, as per the, my Lord, I have obtained certified copies of the orders and I've annexed it with this application. My Lord, will come to page 36 of my application, my Lord.
Okay, 36.
36, Lordship.
Yes.
My Lord, on 30th of January 2023, my Lord, I had filed my application if Lordship sees the order, first order, 30th
Yeah.
of January.
Yes.
My Lord, yes, my Lord, and my Lord, since then, Lordship, there has been several hearings before the learned judge, and my Lord will finally come to page 62. My Lord, these are all the orders that have been passed. An interim order was also passed in my favor, and my Lord, in the meanwhile, my Lord, the presiding officer was also changed, my Lord, because there was a transfer. And at page 62, my Lord, will see that the date for final hearing was fixed, my Lord. Party 17th of November 2023, Lordship. Kindly read with me. CR put up today, Counsel for Respondent, so-and-so, Counsel for Petitioner, Counsel for Respondent. Parties agreed to fix the matter on 8 December 2023, fixed for 8 December.
Which page reading? 62.
Page 62, Lordship.
13, 12, 23.
61, my Lord, I'm sorry, my Lord, 61. It was fixed on 8 December 2023.
Yes.
And my Lord, thereafter on 13, the next page, my Lord, next date is given 14 December 2023 for hearing. My Lord, this was the last day, my Lord, the hearing was concluded in presence of both parties. And my Lord, from page 64 onwards, Lordship will see that the matter was reserved for passing of orders. Page 64 onwards, Lordship.
Okay,
and
yes.
My Lord, no order has been passed. We have mentioned the matter on several counts, my Lord. My learned friend, Mr. Amit Joshi, is present before your Lordship. He has personally visited the court. I am from Calcutta, my Lord. I could not come on all dates, my Lord. And we've mentioned the matter. We've supplied all kinds of assistance that was required from the learned judge, my Lord. Despite that, my Lord, till date, my Lord, no order has been passed. And
Yes, you know something, MS Charaji, that's your name, correct?
Yes,
this judicial officer died, I think, he died, when did he die? He expired on March.
No, my Lord, nobody has expired, Lordship.
No, the presiding officer who heard your matter, he expired.
No, my Lord, the presiding officer was changed in between. A lady presiding officer
After he was transferred.
Yes.
Okay, after his transfer, it came before whom? Because still record Irumbui here. Even this order dated 23/2/2024 at page 65. The case pending
64, Your Lordship.
Page 64.
Yes, Your Lordship.
Arumbai, then how come 65? It's 23/2 and 9/2/2024. Then they have to correct it.
That's what, Your Lordship.
This is very unfortunate. I mean, if this district court, the staff there, how can they record that officer's name? Yes, sir. Take down. What do you want now?
My Lord, let an order be passed, my Lord. This application has been pending. It is an application.
No, we will
praying for
we have to
custody.
issue notice. We can't pass it ex parte. Yes, heard.
Yes, sir, if notice be
your-
issued, my
your-
Lord, let
your-
the other party come, my Lord. They should
Yes.
not have an objection either, my Lord, because both parties
Okay,
are
heard. MS, your name?
Ujjaini Chatterjee, my Lord.
Yes, also for the
UJJAINI.
petitioner with Mr. A. Joshi, issue notice, returnable in 2 weeks. Steps to be taken by said AD within 3 days. List
My
accordingly.
Lord, can the matter be fixed anytime after 6th of June, Lordship?
Yes, they'll give a date.
Anytime after 6th
List
of
on
June.
so. Yes, after.
Item number 2.
Grateful, my Lord.
My Lord, this matter relates to Land Acquisition Act, my Lord. My Lord, in 1975, there was an agreement entered between Bangladesh and India that until the finalization of the boundary, international boundary, both countries should not utilize, and the boundary erected by the parties are temporary in nature. Now, in 2021, my Lord, on 11 June 2021, the government has issued a notification under Section 11 of the
11
Land
June 21.
21,
Yes.
notifying my land for acquiring for the purpose
IBBF.
of fencing.
Yes.
Yes, and on 24th August 2021, they have issued a Section 19 also.
20?
Thereafter, 21, my Lord. Thereafter, my Lord, we have filed a first writ petition, WPC number 496, which is still pending. The collector also filed the affidavit, and they admitted that, yes, we have issued the Section 11 and Section 19 notification. Now, during the pendency of the first writ petition,
Yes.
they have issued a fresh, my Lord, Section 9
496 of which year?
of 2021.
21 writ petition. It's
Yes.
still pending.
It is still pending.
Which code?
My Lord, it is pending before courtroom number 3 for admission.
For admission?
Admission hearing.
Is that correct? Why is the pending for admission if it's 21 matter?
My Lord, here, if my senior is referring to the case which is pending before court number 3, my Lord,
Yes.
here, my Lord, affidavits were not filed. And subsequently, it was the petitioner who keep on praying for time, saying that there are some new developments that will bring into record. We have been ready to argue the matter because affidavits have all been filed, especially for the state and the union. It is a
Take this
petitioner.
matter together with that matter?
However, my Lord,
that
here,
can be done.
my Lord,
If
here,
Lordship
if
permits.
Lordship will see the cause title of this instant case, my Lord, at page 17 of the writ petition.
No, if it says a continuation of the same cause of action.
But, my Lord, the respondent number 6 and number 7, if Lordship may kindly have, my Lord, page 17. My Lord, on the last page 17 of the writ, my Lord.
17.
These are new two parties.
My Lord, may kindly have page 17, respondent number 6 and 7. Lordship will recollect, it was just taken up last week. A petition has been pending before this Lordship, filed by respondent number 6. Here, the petitioner before today, my Lord, he has filed an implement application.
So, what matters that?
My Lord, this is also with regard to IBBF matter, my Lord.
Same plan.
My Lord, same,
My Lord,
same,
this
may I
was
just
the
explain?
petitioner, my friend.
My Lord, may I explain briefly? Now, during the pendency of my first writ petition, government has issued a Section 11 and Section 19 declaration, removing the names of the recent writ petitioners and removing the names of the writ petitioners and inserted the Toloi as a landowner.
Okay.
My Lord, and he claimed for the compensation. When he claimed for compensation, the private respondent number 7, Mr. Erwin, came forward and object. So the Toloi has filed a writ petition before this court seeking for direction to allow him to withdraw the compensation.
So who's the writ petitioner in this for the Toloi in that case?
Toloi is the petitioner. Toloi is the petitioner. And since they did not implement me as a party, so I sought for implement. Not sure
Which
notice.
WPC is that number?
WPC 416 of 2023, my Lord.
416.
And the 416. And this case is coming on 28, my Lord, as per the SCIS, my Lord. And here, my Lord, we are yet to file objection to the implement application, my Lord, filed by the present petitioner, my Lord. So, my Lord, it more or less,
so what
my
do you
Lord,
want a court to do?
My Lord, this matter can be taken up together.
Different levels and have nice conflicting orders.
No, my Lord, if this matter can be taken up together, my Lord.
Which court will take up all matters together?
My Lord, I'm praying that this present matter, my Lord, which is before motion, my Lord, this should be taken up with 416 of 2023 because...
What about 496?
My Lord,
496, he says that in the earlier notification, their names figure there. And
My
they've
Lord,
come...
if that is so, my Lord, they have to withdraw that petition and they have to go with this present petition, my Lord.
Cannot be done. It cannot be done, my Lord.
Cannot be?
My Lord, we cannot withdraw the first writ petition, my Lord.
It doesn't amount to liquidating or annulling your first year in your cause of action for the
My
first
lord,
petition.
best may I pray, it may be heard together.
Who will hear that together? You have 416 pending for this court, right?
My lord.
Yes.
Now you file a fresh writ petition. Now 496 pending for court number 3.
My lord.
Pending for admission hearing.
My lord.
Admission hearing. Exchange of exchange
And my
of a
lord,
pleading
there we have
completed.
also informed the court that a number of the landowners have been given compensation, and we will be coming up with a list of people who have received
And
compensation.
the lawyer, where does he come in? You receive some compensation?
No, Lordship. In fact, the dollar is not representing his individual in the individual capacity.
Yes.
He's representing the Elaka, Lordship. So he's not claiming compensation on his.
No, you have come with what prayer and that in your in 41623.
In 416, Lordship, there was a notification issued by
416,
the
sorry.
government. Now the entire acquisition process has completed. Only award was to be given, Lordship. Now this respondent number 7, Mr. R.N. Sutuna, he came forward and filed one paper of objection, and the DC has directed the Ilaka and the so-called objector to settle the matter. Against that, we had come before your Lordship.
And we have also told him to substantiate his claim, which he has failed.
So then it is not linked to this matter.
Because it's somehow linked because
It will
it's
be
the same
linked,
land,
my lord. It will be, the area seems to be same, my lord. Perhaps, my, if Lordship may have this matter together, we'll be able to assist.
So we'll call for the records 496 here and take
496, so I think no.
496
no
may
cause of
not be
action was
required,
required.
my lord. 496 may
cause of
be
action
before the same
Together,
court.
all 3 writ petitions. If Lordship issue notice, let them file a short affidavit and club together and heard together, madam.
Yes, heard Mr. H.L. Sanreso, learned counsel for the senior counsel with so for the petitioner. At the outset, the learned senior counsel has apprised this court that with regard to the same same piece of land, wherein the Indo-Bangla border fencing is being put up, an earlier writ petition had been filed by the same writ petitioner, being WPC 496 of 2021, which is pending hearing for a coordinate bench. It has also been brought notice of this court that another writ petition being WC 416
filed by
2023 is also pending adjudication. He submits that as all these matters interconnected, perhaps the 3 months be taken up together for consideration by this court. You don't object to that?
My lord, I do not object.
Yes, Ms. Arkoli appearing for the state respondents.
1 to 5.
And Mr. M.L. Nongpure appearing for the writ petitioner in WC 41623 also accede to this request.
Copy has been served.
I have not been served with copy.
I will serve copy.
No, it doesn't matter. Actually, to hear together doesn't. Yes. Accordingly, let the records of 496/2021 be placed together on the next date, along with the present writ petition and WC 416 of 2023. Just after
2 weeks.
My lord, 416 is coming on 28th May, my lord.
Yes, on 28th May.
Lordship may allow me to take step with regard to number 7.
Of course, a petitioner to take steps for service and notice on the part of respondents in the meanwhile. Yes.
High leverage.
Item number 3.
May please, your lordship. This is a writ petition against a notice issued by the respondent, asking
Notice?
to issued by the respondent.
What notice?
Notice of shifting of the market complex, my lord. Occupants of the market complex. Here, my lord.
Eviction notice, you mean?
No, my lord. This is just a request letter, my lord. There is an encroachment in the right of way of the government, my lord.
Let's see that. No, he says notice. Where's the notice?
This is in page 17 and 18. The notice.
In very reference, I'm going to inform you that your establishment is currently encroaching on designated public land. You made the shop on the road?
No, my lord. It's a market area where we are occupying it long before.
Located?
It's Shalang area, my lord.
Okay.
So we have been residing there, and we have a registration paper also. And we are
there means you have your
with
shop
the
establishments.
Yes, shop established. No, my lord. Entire land is been recognized as the land of the ancestors of the occupants of that place. So we have constructed house, residential as well as commercial houses. So we are doing business, small business, my lord. We are doing.
No, but it's a notice only that the subject encroachment on preliminary land.
That is we are
right of RW means like
we are disputing.
The space, like it's the between the road and the land. Then the right of way, you have to certain areas to be kept free for traffic.
No, not those areas, my lord. After the land, after the road.
Lord, we have just made a request, my lord.
For shifting and relocating the entire shops and.
It's not that we are conducting any coercive action, man. This is just a request letter, man.
Now, RW is how many feet from the...
That I have to seek, my lord.
There are so many people, my lord.
I'll have to seek instruction, my lord, on that.
So what is the only thing is that here, where's your prayer?
My prayer to...
Now, where's your title deed? Now, let's see first. Who issued it?
It's issued by the executive engineer.
There's 13, my lord, and there's the type copy.
13. Have you made same announcement in party?
Yes,
also?
yes.
Yes,
This is issued announcement same shape.
Respond number 5.
The price of the land, okay. Are these people named here, the petitioners here?
In the registration. No, this is in the name of their ancestors, my lord.
No, but who are these people then? How did they connect it to this document?
They are
shown that. How you should? Let's see. The petitioner is Lois. What?
Petitioner belongs to the same clan, my lord.
Now, how is it connected to this? This is the land of Dorangre Songsak.
Yes.
Now the names are given here.
No.
The names are given here of people who settled this land. Now, how is he connected to these people?
They are their grandmothers and
Which one from
ancestors.
the numbers? Yeah.
Number
grandmother. Have you said anywhere that the
it's
petitioner is
Srimati Mining Sonjak is the grandmother of this petitioner. It's in page 13, number 2. Name.
No. Where is it in the writ petition that the writ petitioner is the successor interest of so and so is mentioned in that title document?
Nothing, my lord.
Where's the connection? If you have to base your right on something, you have to show, substantiate it. That this petitioner is
in paragraph 5, my lord.
No,
the ancestor. This, my lord, this place called Riangsi, my lord, is a big area. It was been occupied long before, my lord, and thereafter it was been recorded and registered with the.
Is it a village or is it?
It's a village type.
And who's the headman of the village?
My lord, there is no headman. There is agentship is there. They are maintaining their own clan on their own way, and the register.
Coming forward to establish your own title and interest over the piece of land, or over the clan land, or over village land.
It's a clan land, Riangsi, called as Riangsi land.
No, I mean this petitioner whom then?
My lord, belong to the Riangsi place.
So who is he?
He is one of the occupant of
resident. So he has a particular piece of land.
Yeah, he is occupying.
And where is it described?
No, there is no description, my lord, because in the market area.
Then how will we pass orders to say that? Then can we have blanket orders?
No,
we can go construct something else in the middle of the road somewhere, and you say that there is interim order protecting this court.
This is a marketplace, my lord.
See, Mr. Nath, you help the court. At least you come with specifics.
There is demarcation, my lord. Demarcation we could not get initially. Our boundaries.
Where exactly is the shop? Where exactly is the road? How much land do you occupy? What kind of establishment do you have?
My lord,
are you engaging some kind of business?
My lord, immediately we could not measure it. My lord, we have to measure because there are so many, around 100 people are affected, my lord. So my lord will demarcate it and will file additional, my lord, of boundaries, my lord. There are small shops.
This is very vague, my lord. So, my lord, no way is related to. There are as many as 26, my lord. It seems allegedly they are the.
No, that's not right. Even then, whatever right they have come to court, maybe they have some right, but then he's not put it across in a way
Exactly,
that the court can pass
exactly.
any
Where is this
even
locus,
for
my
protecting
lord?
you also.
My lord, there are a bunch of cases, my lord. Along with this, we have filed separately, my lord. So that boundaries and demarcation, could not be measured now, my lord, because of the urgency of.
Why is there a deadline for you to vacate?
No, my lord, it's just a request letter, my lord. Kindly see the wording, my lord.
Take down, heard Mr. H.R. Not counsel with the petitioner. This petition directed against notice dated 15th January 2024, whereby the petitioner.
That notice was received on 19th April, my lord.
It doesn't matter. 15th June 2024, when a petitioner has been given notice to remove an alleged encroachment on the designated PLD land (right of way). Stop. Mr. H.R. Leonard Counsel petitioner submits that the petitioner and his ancestors have been in occupation of these lands since
more than 40 years, my lord.
For over 40 years. Stop. He prays that some interim protection be given in the meanwhile. Stop. Mr. Arkurung Larat GA, appearing for the respondent state, submits that appraise he will have to obtain instructions, and further submits that it is only a notice and is not an order for immediate eviction. Stop. This court notes on hearing the counsel petition, perusing that the area is not well described, and apart from the notice indicating the petitioner's name, no other details are available to show his interest or whether he possesses any lawful right over the land in question. Stop. Just after 2 weeks for instructions.
My lord, interim order, my lord, till the return.
We don't do anything.
It's just a request letter, man.
We can't. We then you see, you pass interim orders. Now, wherever your land is, suppose you start building something else. It's like passing an anti-speed bail order without a case number.
3 to 11
you
are.
come before the court and say give anti-speed bail for so and so, and then like we give anti-speed bail. The police not arrest you, and you start committing right and left crimes after that.
We'll file our
3 to 11 are connected.
We'll file additional, my lord.
Notice to private respondents within
3 to 11.
3 days.
Number 8, my lord. I am
We'll give the name. 3 to 11, my lord.
3 to 11, same.
Yes, sir. Mr. R. Gurung and Mr. Nadis.
Deeply obliged.
Item number 12.
Why are you keeping different counsels for the same matter? It will be utterly confusing. There should be only one counsel. One senior government appears enough for this matter. They're all identical. Spreading state largesse.
Please, Your Lordship.
There has to be some direction in the way the government office run also. Public interest also will be there. Yes.
Please, Your Lordship, this is a writ petition. Just one prayer that I needed regarding the stay of one letter. Before I come to that, Your Lordship, I just want to briefly, Your Lordship, what had happened in 2005, the petitioner had filed a suit before the District Council against the respondent number 4 and 5. Now that suit is still pending. Now during the pendency, 4 and 5 are the...
Oh, I'm not able to take this matter.
I have checked, Your Lordship.
Let me check. No, don't know these people. Yes. Yes.
So this is in respect of 3 plot of land known as...
Suit was filed 2005.
2005. In
What
respect
happened
of...
to the suit?
Now, still pending, Your Lordship.
Still pending now
Still
also?
Pending. Now pending.
At what stage?
Now, evidence. Now, what had happened, it's not connected to the respondent. I'm not asking any relief from the respondent.
I'm saying we filed a suit in 2005.
2005, still
now
pending.
it's 24. Yes, 20 years.
Yes.
Yes.
Now, during the pendency of this suit, the respondent number 3, which is the additional DC revenue, had issued one letter last year in the month of August, letter dated 7 August 2023. Lordship, can you have that letter, Lordship? That is at page 30.
30.
This letter is addressed to the Kur. Kur, thank you.
Yes.
Who had asked us to come and appear in person in respect of this Thank You Clan property, serial number so and so 161 LHS and 193 LHS, to bring documents.
MB Tong Pair so and so 18 August clarified ownership of land appearing as that of a serial number so and so. Okay.
Yes. Now against
Riboy district.
There are 3 land, yes, Riboy. Some of it, part of it are in East Kasales, part of it are in Riboy. Now this we have issued, we have submitted one letter that is at page 31. Now the prayer in that letter is that we had informed the respondent number 3 regarding the pendency of the suit, and also requested the respondent number 3 to conduct an inspection whether or not this particular acquired where they have proposed for acquisition, does it fall or not. They have not done any inspection. And this year, they have issued another letter. That is at page, Your Lordship, can you come, page 53, Your Lordship.
Who issued letters? One number 3.
ADC, yes.
Yes, what do you say?
They are asking the same thing, to bring the documents. They have not, to our request to conduct the inspection, and instead issued this letter, again to bring documents. Now, against this letter, we have again issued one representation requesting the same thing. Now, we have also appeared in person before the respondent number 3.
One second.
Page 53.
Okay. You want a compensation to be kept?
No, we don't. Yes, to keep in abeyance. Yes.
Will release to whom? You mean?
It should not be released to anyone pending disposal of the.
Who wrote this letter? This letter dated.
This is by the Rangba Akur.
So now you say that this is your land.
Yes, I'm saying in the suit. Yes, I'm saying my land. Since the suit is pending before the court, so I just request.
But these people who signed, are they the defendants in the suit?
They have authorized the petitioner in the suit
to file a suit.
Yes. In this letter also, they have referred to this suit which is pending before the court.
What's that? If you have brought notice, Joanna? I don't understand. The suits between you and
the respondent number 4 and 5.
Where are they in the picture now? In this,
they have not received a letter. Letter was not addressed to them. But since this land is in the name of the court.
The names have appeared notification.
Yes.
4 and 5.
4 and 5.
Where is that?
This notification is referred in that letter, page 30.
Have you annexed the notification?
That I don't have a copy, but it just referred here in the letter that it is serial number so and so.
These names are given.
Yes.
The names of these people are given.
Not names, but in the name of the Kur, Rangba Kur. Can you see? Can you have again, Your Lordship? Can you see?
Mr. Marpan, listen. Now you file a suit against this 4 and 5, correct? With regard to certain piece of land. Okay. Now you say that the suit's pending, and now the notifications come out for some western bypass, whatever.
Yes.
And then this land question is going to be taken over. It's going to be acquired.
Yes.
Now you have come here to pray that the compensation not be released to any party.
Yes. That is all. Construction may continue. I have also given the undertaking that the construction may continue, but the compensation.
No, but then is there any threat at all? Because
yes, because we have appeared before the ADC revenue. They have not given a positive response. They have said that they are proceeding.
3rd May 24.
My Lord, it appears a compensation is yet to be decided whom to be given, the actual rightful owner, my Lord. So
what happened 8th May 24 in the hearing?
On the 8th May, we have submitted this representation. On this hearing, we have submitted informing there is a suit pending.
Page 53.
Yes.
Yes.
This is the letter, again, a recent letter which they have issued to us to bring those documents. Now, against this letter, we have issued this letter, page 54. again requesting the
No,
the
this is not your letter.
No, my lord, 8 May, what happened, it's not here, my lord. What actually happened on the 8th of May? Because a
It's not
meeting
here.
was called.
It's incomplete. And if this is not your letter. This is a letter of is Rombakur or something.
Yes, Rambakur, but they're acting on our behalf because
Why shouldn't you go? Is it clan land or personal land?
Clan.
Then who are you then to agitate for clan land?
We are the members of the Kur. They have authorized us.
Where's the suit?
Suit, Lordship, please, can you come up and close the plane, Lordship? That is at page.
Where? Can close the plane?
Starting from page 46, Lordship.
The plane?
Yes. Page 46, Annexure 6.
46.
Yes, sir.
Yes. Okay. You are the descendant of the occupant
Yes.
of this land. That's all.
Yes, Lordship.
Okay. Oh, this is clan land, but then you're suing as if it's a private land.
Because the other side, they're also claiming that they are.
See, your declaration is seeking for declaration suit land is a joint property of all descendants from the womb of late Rimon Thankyu.
Yes.
That means that for your claim from one grandmother, that means that she's the owner. It's not clan land anymore. It might have been clan land before. That means then that is why it's your personal interest involved. It's not a question of clan interest any longer. But then now the clan elders have come in and filed representation. You should have filed a representation. The notice shouldn't have gone to them just because it's shown as clan land and notification. Bring notification also. Heard Mr. S. Marpan. Otherwise, issue notice. Yes, anything to say?
My lord.
Just obtain instructions.
Yes, my lord.
Whether what stage is acquisition process?
My lord.
Yes,
and it appears compensation has not been given. We have been calling all the stakeholders, my lord, all this while.
That Ms. S. Marpan, the council petitioner, issued notice. Ms. Arkoni doesn't accept notice on behalf of
1 to 3, my lord.
1 to 3 notice to issue to the remaining respondent in 3 days. Stop. Ms. Arkoni prays for allowed 2 weeks time of instructions.
Lordship, there's a miscase that are filed to.
Of the acquisition.
My lord, let me have instruction, my lord.
Yes. On so and so, this application will be taken up on next day for consideration.
Item 13.
It's not clan anymore. We're agitating it for your own private land. That's why you filed the suit yourself. Yes.
Lordship, here I am challenging the appointment of the private respondent number 6 and 7.
Teacher.
Teacher, Lordship. That Lordship kindly come to page, Lordship. Page 14, Lordship. When did the vacancy arose and when did...
Page 14.
Page 14, Lordship. When the appointment was made, Lordship. Page 14.
August.
May I read, Lordship? This is an order issued by the respondent number 5, Lordship, the headmaster. On attending the age of so-and-so, Sri Jontri Rava, assistant teacher of Potamati Non-Govt LP School, under Dadingiri so-and-so, is hereby retired and released from his respective service with effect from 31st August 2022. That means he retired on 31st August 2022, Lordship. Now kindly see his order of appointment, resolution, Lordship, page 16, Lordship.
This is taken on?
6th July 2022, Lordship. And on the same day.
31st August, this is 6th July, yes.
Yes, Lordship.
Yes.
Lordship, that resolution number 2 and 3 is her appointment, Lordship. And it specifically mentioned that in place of Jontri Rava, that she has been appointed. How can she be appointed before the vacancy arose, Lordship?
There was no advertisement.
No, there was no advertisement, Lordship. And prior to Lordship, prior to that page 15, it is the NOC issued by the headmistress of the school. The NOC was 18/8/2022, Lordship. But before the NOC...
This was a sanction post?
Yes, Lordship. This is non-gov. Before the NOC, Lordship, they have already filled up the post, Lordship. There are 2 appointment, Lordship. Here also there was no... The respondent number 7, Lordship. In similar way, 2 appointments were made in the year 2019, Lordship. There was no advertisement. There was no selection board.
Same school?
Same school, Lordship. Page 20, Lordship. Page 20, resolution number 2, Lordship. 23rd October 2019, Lordship. Resolution number 2, it is resolved that the managing committee is very pleased.
Are you asking for setting aside of 19 order also?
Yes, Lordship. Because these facts were not
now you're asking for...
revealed.
You're seeking 2 release and 1 petition?
Yes, Lordship. Because none of the appointments were made by following due process of law, Lordship.
Yes.
Your Lordship, I'll accept notice on behalf of respondent 1, 2, 3 and 4, Your Lordship.
Petitioner issue notice, returnable in 3 weeks. She's already been appointed with upon order.
Yes, Lordship.
You have next upon order?
Yeah, I have annex, Lordship.
That is
The appointment order is at page, for respondent number 7, page 22, Lordship.
Yes.
For respondent number 7, page 22, and for respondent number 6, page 18.
No approval from the government?
Approval, Lordship, for respondent number 8, page 23 is the approval, Lordship.
Okay.
RTI was filed, he refused to.
Yes, ad-hoc, no? Yes, MS Ailingwa is present accept notice. We have respondents.
124, Your Lordship.
124. A notice to remain respondents by the
5, 6 and 7.
within 3 days. Yes. This is the rapporteur also for instruction affidavit.
Obliged, Lordship.
Item 14.
Yes, Mr. Shulai.
Lordship, just may it please your Lordship. Lordship, so far 2014 SSC online that is Kerala, Your Lordship. So far, the fact of that case, Your Lordship, is distinguishable, Your Lordship, from the fact in the present case, Your Lordship. Because in that Kerala case, Your Lordship, there was a case registered under Section 21(4) of the Mine and Minerals Development and Regulation Act 1957, Your Lordship.
1 second, let me get the compilation.
Lordship, kindly have a look at 2014.
Abdul Majid.
Lordship, yes. Anfar Beso State of Kerala.
Yes. Yes.
Lordship, there was a case registered, and that property which has been...
No, just the proposition that they didn't put forward. Whether now by your own affidavit says no case registered, no proceedings before any. Then what remains? You have nothing to say about that.
Because what happened, Your Lordship, in this case, there was an order of the NGT, Your Lordship.
Right, NGT order is there, but doesn't mean that NGT order will take with the powers of the executive of a court.
Lordship, yes, there is no case registered, Your Lordship.
Then where could have gone to say that we're innocent and then that the vehicles were seized are not involved in, That's the court to examine and the court to assure that, they produce as the case.
Lordship, from the additional affidavit which we filed, Your Lordship, there was a report submitted by the concerned police to the superintendent of police.
The court agrees also.
Lordship
but the procedure has to be followed.
Certainly, Lordship is correct, Your Lordship. Only Lordship will grant us the liberty, Your Lordship.
There's no need for liberty. You have to appeal the court.
Lordship, yes. As and when the case is registered, then she's bound to...
Yes. We'll do that, man.
Yeah, then we'll pass orders.
Lordship.
Yeah, that's the only thing. If there's no case registered, then...
But in fact, the second decision which I've cited, my lord.
Yes.
Here was a case, no case registered, and on the strength of NGT order, they are trying to pass some order, my lord. The Punjab and Haryana High Court very categorically said, my lord, in para 12 and 13. You can't do that.
What case is that?
Second flag, my lord. 2020 SCC online. Irfan versus State of Haryana, my lord.
In that case, FIR had been registered, Your Lordship. In all these cases, Your Lordship, FIR had been registered.
This is even worse, they have not even registered FIR.
See, whatever it is, it might be blatant, those machines, excavators, might be used for illegal purposes, for extracting, and then there might be NGT proceeding against the person who hires machines. But the machines are separate. Now he's come forward saying that I've hired out my machines and they're just being kept in your custody without any proceedings before any court.
The facts on record is that, Your Lordship, the people
that
who have taken on lease those property, Your Lordship, they have no permission or license from the state police.
Then he should have taken them the court. They won't give them out to them. Or make them the other what do you call it, procedures you can adopt, not just to hold them like that. Yes.
My lord, they cannot do every coal seizure, my lord. They're registering a case under section 21(4). The sand cannot be a bigger offence than coal, my lord. This is otherwise a minor matter, my lord.
Even then, the way the quarrying is going on is very unfortunate. All the wheels are being flattened.
That's
to fuel the construction boom in Guwahati.
Destruction of the environment.
But then if you destroy your own case, what to do?
A Lordship.
Yes.
Apply, Your Lordship.
Daily list item number 1.
He's seeking for time.
2 weeks time, my lord.
Why? For an official hearing today.
My lord, the conducting counsel is out of station.
Who's going to Mr. Molong?
Mr. Sinkan. Mr. Sinkan.
After 2 weeks.
Much obliged.
As it is submitted, the conduct counsel of station, this is matter after 2 weeks, yes.
Much obliged.
Any urgency?
Urgency, my lord, we have filed an application before the trial court for keeping in abeyance the entire probate matter, since the matter is pending before
the probate matter?
Probate
Yes.
matter. So that habit can be abeyance.
Item number 2.
Please, Your Lordship. Lordship, this is a Lokmaship matter, my lord. Here we are aggrieved by the...
Have they received notice?
That notice has not been issued to private respondent number 5, my lord.
Oh, apparently, yes. Correct. Where's Mr. Day?
He's next to courtroom 4, Your Lordship.
Courtroom 4. Yes, start.
Yes, my please, Lordship. Lordship, here we are aggrieved by the impugned judgment and order, my lord, passed by the Deputy Chief Executive Member and the impugned judgment and order passed by the Chief Executive Member, my lord. Herein, the Deputy Chief Executive Member came to a finding that the petitioner's Akang and the respondent's Akang are the same Akang, my lord.
Are they?
They are the same Akang land, my lord. Wherein the petitioner's Akang land is registered under Moza number 324 and the respondent's Akang land is registered under Moza number 210, my lord. So these basically are two different Akang lands, my lord. But erroneously they have come to a finding that it's a same Akang land, my lord, without following the principles of Dore Sangma case, my lord. That is the crux of the matter, my lord. Here, what has happened, my lord, the petitioner's predecessor were the early inhabitants since 1905. Early inhabitants, my lord.
Okay.
Since 1905. This Akang land was given by one Jingat Sangma, my lord, from Chismokre Akang land, my lord. That issue was never framed, my lord, and the evidence was not taken. So that is very crucial for this matter, my lord. If it is ascertained that the Akang land of the petitioner has come out from that Jingat Sangma's Akang land, my lord, Chismokre Akang land, then we have got a case, my lord. If not, then we don't have a case, my lord. But that evidence was not taken. That is my case, my lord.
Let's see the impugn order. What are the findings?
Findings, type copies at page 45, my lord. This is the impugn order passed by the Deputy Chief Executive Member, my lord.
You've come straight here, didn't go to see him.
No, I went to see him, my lord. This is the initial order, my lord.
Okay. After going through all the records?
Yes, after going through all the records and GT, the confusion is now clear in the regards to the Amate 324 and due to the use of different names of Damal, Gambal, Nokapkri, Rongdokre and Moza number at the time of registration of the objector respondents Nokma, a confusion have arisen and therefore this court is of the opinion that the claim made by the petitioner to register themselves as Nokma of alleged Amate Chibongre 324 is without any basis or merit as are claiming the same Akanglan of the objector and hence the petition cannot be entertained as it is barred and has stopped me from further adjudication to let the petitioner to register themselves as Nokma of the Amate Chibongre 324 as claimed by them, which is well within the Akanglan of the objector and the map drawn and submitted by the petitioner to the Mozadar in the previous report dated 15/3/2018 cannot be accepted, which map is similar to the Akang map of the objector respondent and I do not find it fit to disturb the same. And as far as the correction Akang name and Moza number is concerned, this court direct to make necessary correction of the Akang name and Moza number from Damal Gambal Nokapri 210 to Rongdokre 324 in the GT and all the related papers.
The finding is that
it's the same Akang.
It's the same Akang.
Yes.
Only that somehow they were given two more than numbers.
Yes, but that is not even in the record, my lord.
How is that possible?
No, that has been ascertained.
In the record must be there.
No, it has been ascertained.
324 and this one is Chibongre.
It has been ascertained by the revenue officer, my lord, who has gone for inspection. My lord. So if lordship wants to see the inquiry report, my lord, that would be at annexure 5, page 30, my lord. That will be the relevant portion. 30, my lord. This is the type copy.
See that, yes.
Kindly come to para number 2, my lord.
Yes.
Point 2. The Damal Gambal Nokapkri Akanglan is recorded as Damal Gambal Nokap 210 from the period when Sri Chaksing Marak 30 was registered as Nokma on 4/10/16 and the reason why the Damal Gambal Nokap Akang 324 was recorded as Damal Gambal Nokap Gri 210 is not revealed in the office records. Actually, the whole area of Damal Gambal Nokap Gri is fall under Moza number 3.
The clear finding, this is a finding by whom?
This is a finding by the
revenue
officer, my lord. Here, para 5, my lord.
The finding on fact.
5 number, my lord. Kindly come to 5. The reason why Damal Gambal Nokap is called Rongdokre is not revealed in the records of the office.
But the finding of fact that the map prepared by Raksan Marak of Chibongre is similar to the same of Damal Gambal.
Our case is, my lord, that the Akang land was demarcated, was given by Jingat Sangma, who is, he was the Nokma, who was the Nokma of Chismokre Akang, my lord. And that Akang registration number is Moza number 322. So that was never ascertained, my lord. Issues were not framed. Evidence was not taken. That is my case, my lord.
Yes, Mr. Day. Now the findings, okay, revenue officer rendered the finding. Now the finding of the deputy thing, he just says that going to record confusion. Okay, they won't. Was there any necessity to let them read evidence? Do they have any materials to substantiate?
Yes, there is a genealogical tree, my lord, page 22. This a type copy of annexure 2. If kindly come to that para, my lord, the land has been
gifted by Jingat Nokma because I'm going to ask for it, and the same was gifted out of love affection thereafter.
The boundaries were demarcated, my lord. The land in question is land gifted by Jingat Sangma to Salgan Marak. The reason for not being able to register himself Nokma for demarcating boundary is because of poverty and also due to ignorance and illiteracy. For this reason, the Maris were willingly, unanimously came to arrest the Nokma of Chibongre Moza number 324 Akang. Hello.
Yes, Mr. Reddy.
Well, this appears to be the resolution of some meeting where my
No,
lord.
what Mr. Momin is saying that now what happened, they have come for to try to establish their claim with regard to this their arcing. But then the finding is that is one and the same, although two more the numbers were given and different names are there.
That is the claim made
That's
by
the
the
case.
petitioner.
And so
Yes,
they said that the inquiry that was done, I mean the inquiry or the consideration or whatever was done by the deputy CM was wrong because it was very superfluous. It means superficial, without hearing them and without examining the matter in detail.
What about the appeal, my lord? The appeal order. If my lord may kindly see the appeal order.
Yes.
The last page, my lord, 52. Further, while going through the record, it is found that the Mozada report. The last paragraph. Further, while going through the record, it is found that the Mozada report that they have.
That's the same thing. That's
the
same thing, my lord. That he read earlier.
Yes.
That,
now, my lord, here, my lord, if my lord kindly see what they have produced before the court is a GT, and that GT is in dispute, my lord, because GT is initially prepared by the then deputy commissioner. They have no document to show that the GT was prepared at that point of time. Now we are just maintaining the record, and we are adding and removing the names of the NOCMA, my lord. But the GT is originally prepared by the deputy commissioner. Where is that record, my lord? If that record is not there, my lord, they have no case.
So that is what we are saying, my lord. Evidence should have been taken, my lord. Our claim is that the land was demarcated from Chismokre Akhang. Whether that Nokma was... The statement of the Nokma was recorded, my lord. That is my case. If the statement of the Nokma is recorded and if they have come to a finding, my lord.
He says that let Deputy Chief Executive Member justify in the stand that Amati Aking 324 is settled date 1928 to the prior respondents, I mean to the predecessors of respondents, as per the verification Aking records.
That records also have not been ascertained, my lord.
You have not seen them?
No, we have not seen the records, my lord.
Now, there was before the CEM as well as before the EEM, my lord. Now, only question that comes in
The only thing is come here before is what Mr. Day is that it's not given adequate opportunity to present this case. That's all.
But whether
now, the only thing from the order we have to be satisfied that yes, he was given adequate opportunity to present his case. It was considered and rejected. Fine.
My lord, the opportunity will be given, my lord, when they will have a claim. They made a claim without any substance. Then any person can come, my lord, and say that we have not been given an opportunity.
In this case, there is some substance because how can it be that the finding that there were two Mosa numbers?
Why they are feeling shy, my lord?
For the same Aking then.
I totally.
And if the map they produce, as per the inquiry, the Mosa said that the map is the same.
I totally agree.
Yes.
What is fallen from my lord, but why they are feeling shy, my lord, or what stops them to bring some record, my lord? Even
that's
before this honorable
we have any records?
Lordship, the Mosa number, I mean the map itself says, my lord.
No, do you have any records?
Lordship.
Let them produce some record, my lord. Because
we have produced whatever records we have, my lord, before the concerned officers, my lord.
I will produce the record. Let this
my grievance is simple, my lord. The statement was not taken from the NOCMA.
It's heard Mr. A.G. Moon, the council petitioner, on hearing the council petitioner, and Mr. S.D. for the respondents 1 to
4.
1, 2, and 1 to 4. The matters admitted for consideration. Notices to go to be issued to the respondent number 5 within 3 days. Stop. Mr. S.D. to produce the records of proceedings before the CM, before the deputy CM.
Yes.
Before the next date is.
And whatever documents they have, my lord, they can also file an additional affidavit.
See, if from the records will show whether they had produced the documents or not.
Yes.
And whether adequate opportunity has been given or not.
Lordship, from the
only
record.
thing is that I was not given opportunity, I was not heard. No evidence was led whether to establish whether there's the same reliance was placed on that inquiry report of Mozadar and the finding was rendered. That's his case.
That's my case, my lord.
My friend case is also this, my lord, and NOCMA has given him a land, my lord.
No, that's on facts. But on the process, he is saying about process that I was not given opportunity because an inquiry report was given by that Mozadar that was taken by the deputy CM. He said he accepted inquiry report, the same land, those 2 Mozar numbers and aberration. So he dismissed the case. So we've not heard their appeal again. So that's the thing. Anyway.
what I want to point out is this, my lord.
Yes.
If he has some record, even a portion of land has been given by an ex-Nokma, my lord, that record he should have enclosed, my lord.
Well, if that's the case, let's see the report.
Item number 3.
Hello, my lord.
In terms of the last order, Lordship, we were supposed to file the substitution application, Lordship, which we have filed, Lordship.
It has been filed?
Lordship, it has been filed.
Who's appearing for the? You're appearing for the successor interest.
Sri Nogen Marak is the son of the deceased respondent number 3, who is the earliest Nokma.
Yes, a missed case number 68/2024 and WPC number 2118. This is an application for substitution of respondent number 3, who expired on 14/4/2022, and respondent number 4 expired on 1/1/2000.
Lordship, he is the respondent number 4. That is what, Lordship, I'm baffled, Lordship, because they had entered appearance on behalf of respondent number 4, and that later it comes, Lordship.
The proposed respondent is one Sri Nogen Marak, who is the son.
Lordship.
By legal heir, Sri, who's the rightful heir and legal heir of respondent number 3 and 4. Stop. What do you want? Mr. Pasantiv, who had earlier appeared on behalf of 3 and 4, please not to seek instructions. Stop. According to this matter after 2 weeks. Name given by you, correct? Then why should you object then? Whether you'll be retained as a lawyer or not. Okay. Yes.
Item number 4.
Yes.
Please, Your Lordship. Lordship, I'm appearing for respondent number 4. So I'm praying for 1 week time to file my counter affidavit.
Why you not filed it?
Actually, conducting counsel, he is on sanction leave, Lordship.
Number 5? It's been filed for 3, 4 and 5. You filed supplementary if it's so.
Supplementary affidavit was filed.
So number 3 is filed. You for number 3. MST Yangi office note indicates that supplementary affidavits on behalf of number 3 has been filed, and affidavit opposition behalf number 5 also been filed. However, today, why you seek some more time? Number 4 is whom?
4 is the current MD, Your Lordship. The current MD.
Okay. So this was allowed for the 1 week's time to file affidavit. This thereafter is also.
Item number 5.
Your Lordship, we have filed our rejoinder, Your Lordship.
Let's have a hearing.
Yes, Lordship.
Parties submit the hearings are complete according to the matter for hearing, and so and so.
Item number 6.
Yeah, the private respondent also have filed the affidavit, Lordship. Number 6.
So you don't define the gender? No need.
It's not required, Lordship.
You can dispose it now.
Lordship, only one respondent, that notice was returned, is a lady actually. But here our only contention is that even the lady in the statement, they have admitted that the private respondent number 6, the police has went to the police station and slapped the petitioner hearing. It is there in this one also, Lordship.
In
their affidavit filed by annexer, filed by the government, state respondent, page 23, first para. They have enclosed.
Zone number 2.
Yes, Lordship.
Where is that?
The first para, may I read? Statement of the complainant.
No, where, which page?
Page 23.
Say that, page 23.
Page 23.
Yes.
May I read, Your Lordship?
Yes.
Statement of the complainant, Srimati Balbina M. Sangma, and the witnesses, Srimati Merita M. Sangma, Sri Tokyo R. Marak, and George M. Sangma, prime accused are.
Prime victim.
Yes,
Prime
yeah, prime, Lordship, sorry. Prime victim are recorded under section 161 CRPC. From the statement of the witnesses, it is learned that they did not see with their eyes of the Asar as they were outside the corridor of Tura Women Police. Also, prime victim stated that accused UBSI robber Son K. Sangma did slap him once at the back of his head, but accused WPSI Renu W. Muman was the perpetrator of the Asar. He was taken for medical examination by the police on that day, on day of the occurrence, that is on 10/8/2023 at around 2:50 p.m. at Tura Civil Hospital. The medical report of the examination had no mention of any bruising mark due to beating. From the statement, it is observed that the timing of leaving the police station on 10/8/2023 contradict with each other. It also learned that they learned about the bruising when they were at the house and at around 9 p.m. My lord, this is the statement where the lady said that.
I only said that this Renu Devon was the perpetrator of the assault. Means she slapped you also.
Yes.
Now what is the medical report? Now the other witnesses didn't see anything.
Medical report, they also have been closed there. It is page 9 of the affidavit filed by the respondent number 5. And they have given the page 9.
So in hospital also you created trouble. It's in the police report given in this report. You also mentioned that inquiry MHO examined George Sangma on 11/8/23 as a petitioner, that is Dr. C. Marak, is learned a family ruckus on the same night at hospital.
The medical report, they says the physical assault mark on soldier HDFC 99% to attend NCD, something they have stated the. That is at page 9 of the affidavit 5 with the private respondent number 5, Sri Robertson K. Sangma. My contention here, my lord, is I am not denying that there is a FIR against me by the private respondent number 6, who is a lady, alleging that I have alleging against me, against the petitioner, that I have done some I have assaulted her, or that whatever that I am not denying. Let the law take its own course. Let me be arrested. I have been arrested in that case also. I got a brain. Now, if there is a case, if I am found guilty of committing that allegation offence, let them convict. But only saying is that while I was in the police custody, this private respondent number 5, he has come and he have assaulted. That is the only thing. Where is the law that anybody can come and just beat me? And moreover, this private respondent number 5 has no jurisdiction. He was.
What does the police? What does the affidavit say? See para 7. Last 4 lines. Read it.
Para 7.
Para 7, the affidavit filed by the state.
Lordship.
Number 2. Read last 4 lines of this para 7. The petitioner concealed the facts. Read.
that in reply to the content of the para 3 and 9 of the petition, the answer is one submit that the legal is made by against this 5, alleging that since beaten up, it was found to be untrue, and there was no act of such. The petitioner had concealed the fact of the case to divert the create confusion with regards to the case which is pending against him. The moreover medical examination which was conducted on petitioner clearly shows that he was assaulted by his girlfriend, not by his girlfriend, Lordship, because to that there is a annexure 20 that page 24 there it will show, Lordship, page 24 there where they have enclosed it.
So who assaulted him?
I'm saying that it is a private respondent and a lady police, not my girlfriend, because that girlfriend is not before this court.
What's written in this? You see this injury certificate. Physical assault by his girlfriend. Bite mark on shoulder. Also, what's this? What about annexure 5 then?
That private respondent number 6, Lordship, is not filed because we have sent a notice, but the only thing is that notice returned to us.
But then see, if you're alleging violence by police, you see the injuries.
What injury?
See the page, annexure 5, page 25. What injuries are suffered?
525.
This medical report must be with you also. Injury certificate.
Yes.
Then?
That injury
Don't read an open court, bite mark on shoulder, hand. Police won't go and bite people.
Lordship, my contention is, Lordship.
Assaulted by, you were assaulted and this is injury report, correct?
Yes, here he's saying that it's my girlfriend, but girlfriend also, but that since this responded that lady make me, she's not here, so she has not filed the affidavit. But then, but what, Lordship, one thing can be appreciated.
Number 6 is whom?
Actually, this is a lady where they allege that who filed the FIR against me, alleging that I'm actually that lady is my girlfriend. Saying that girlfriend has filed the FIR against me. Now I'm saying that let there be FIR against me by the girlfriend. That is okay, but I admit that let that law take its own course. I'm not denying my guilt. There will be a trial and I'll be convicted, whatever may be. But only my contention is that while I was in the police, where I was in the police custody, this lady police, and particularly the private respondent Robertson K. Sangma, who is the police SI, who has been posted in the Armine police station, he has come and trust me, and they have admitted also that that fellow he has come, but he is saying that in the affidavit he just come from he never denied.
And you see what the witnesses say. They don't want to deal with this matter for longer. See what is said here. Where is that? You read just earlier on in the affidavit.
It is page 23.
Inquiry status report. It says that children of the complainant see so and so and so and so are recorded and from the statement witness is learned they did not see with their eyes of the assault as outside the corridor to our women PS. Also, the prime victim said the accused did slap him once at the back of his head. So, according to you, he said that this private respondent, he is an SI there.
Yes.
An armed branch SI, whatever, he came and assaulted you when you went to lodge FIR, or that your girlfriend lodged FIR against you. He slapped, you said only slapped in the back of your head. That's what you said here, correct?
Yes.
Is that correct? That's what you said to the police.
He said that is the police who come and slap.
No, also the prime victim states that accused UBSI Robinson did slap him.
Yes.
Once at the back of his head.
Yes. Yes, he said he stated that.
So your story is that okay, fine, you had a fight, and then this one number 6, he filed FIR against you. You're taken wound PS and assaulted by this Robertson Marak.
Yes.
And also this other lady constable also.
Yes.
They beat you up.
Yes. That is my case.
Yes.
Let this matter come for detailed hearing. I will.
What detailed hearing?
I will assist the court. But thing is that they cannot even touch me. The police officer who is posted at Aramail, and he admitted also that he has come from the Aramail police to the women police station to check the case record. What permit him to slap me when I was in the police custody? He is not even a woman police.
You don't write, this is like counter-blast case, Mr. Sangma. Because FIR against very serious what you have done.
Yes, Lordship, that I'm not denying. There is a FIR against me by the respondent number 6, that lady who is alleging that my girlfriend. I'm not saying that, I'm not denying. There is a FIR against me. I obtained the bail also.
So you also agree that you did all these things, sent FIR against you? Is that page 6, Annexure 1? You took all the educational certificates, you did all this and that. It's a counterblast case. Now you're saying that it's all right. She assaulted you. In jail certificate, surely bite marks. And then now no witnesses saw any of the police who were there with you. Your mother was there. Your friends were there. No one saw anyone assaulting you in the police station. So.
No, they
only that you said that.
Lordship, they were inside the police station. They were not allowed to enter. That's why they said that they only heard the sound.
Yes, Mr. Shulai.
This is the Lordship. Lordship, before I come to the affidavit, Lordship, kindly come to page 4 at paragraph 2 of the writ petition. Can you see the allegation, Your Lordship? And the submission
No,
made.
the report doesn't say anything. We have to accept. Yes, page.
Lordship, page 4, paragraph 2, Your Lordship. Towards the bottom, Your Lordship.
Yeah.
The police, Shri, Lordship is with me, also have used the sticks and seriously beaten up Shri George Sangma, due to which there were several cuts on his both leg of Shri. Lordship, the medical report say otherwise, Lordship. Can you see this statement, Your Lordship?
Yes.
That also on oath, Your Lordship. This statement has been made on oath, Your Lordship. It's a perjury, Your Lordship.
Because to that, Lordship, because they are admitted there is no CCTV footage, so it's not working. The para 6 they have cleared it. Then any can be, because they don't, of course that we don't have the eyewitness, but then the police custody, the police station, the CCTV is the must. Even in our house, everywhere now we put a CCTV footage. But what about this is how can we? They are admitting that CCTV footage was at.
Where are you now? How's the health condition now? Are you still suffering from the injuries?
No, Lordship, I'm not because of the injury, but the manner in which the police are functioning. Number one, my submission is that this police officer who is posted at Aramail, he come running to the women police station after knowing that I'm arrested by the women police because of the FIR filed by my girlfriend. Who is he to come and beat? Who have given a permission? That is the only thing. That I'm not saying that there is an allegation against me by the girlfriend. So
Forget about that girlfriend.
Yes, Lordship.
Only on your own allegations, that's all. Whether they have any substance, that's it. Court examining
Yes,
that. You have come to a court of complaint against police atrocities against you.
Yes.
That's all.
Yes.
Whoever beat you, whatever you had the girlfriend, whatever FIR file against you, we're not right now. Only thing is that you also admitting let's find whatever issues we have with respondent number 6, that remains an issue which is continuing, and you'll face case whatever you are on bail, right?
Lordship,
now, only thing is that you have to establish and prove before the court that yes, there have been police excesses in your case where they've resulted in undue violence against you. That's all.
Yes.
What does Robertson say? I will dispose this off.
Then, Lordship, kindly come to the affidavit.
1 second. Who's appearing for the private respondent?
Private respondent.
Robertson.
Robertson, you are there? Robertson, you are there?
In this case also, my lord, we have already filed an affidavit.
Yes.
Which is in paragraph 7 of our affidavit. That he's coming there, we have already explained also that because he is absent charge Aramail head house West Carwell, and the same was received in Aramail station at number 10 at 7:30 and was forwarded to the OC of Tura Women Place, stating that the respondent number 6 have a relationship since 2021 with the petitioner George M. Sangma. And they have stated clearly there, my lord, that on the 27th July 2023 at 8 p.m. he came to respondent number 6 Vincent House at Darangkre and had forcibly entered the room by breaking the room, which she was also physically assaulted. And Your Lordship has seen the medical report. The medical report does not tally in any way with what my learned friend stated.
Lordship, in the para it just may read because even court has, even this was taken even the what while the petitioner moved the bail application before the concerned court trial below. They have even stated before the court, and the court also has given a summon to the IO and passed some order that they have make a even statement in the para 8 of the page 24. Page 24 of the affidavit filed by the affidavit filed by the private respondent. Affidavit filed by the state respondent number 2, para 8, page 24. May I read? Even this was taken by the cognizance by the court. There was.
Close it, Mr. Sangma.
Lordship, we can close it. Lordship, you can close it, but
why
some
the court's time there?
Lordship, I'm not saying that not to close, but there's that some strong observation should be made against, because my case here is that of course they assert that it may not be so serious, but they have no the assert against me may not be so serious. My only contention is that he has come and he has asserted that is very illegal.
That means your ego is more injured than your body.
No, because even they also, I cannot establish with own eyes that they have asserted, but
No,
the fact is that
the sales report also, even your own witnesses, if you could have brought something to show the court that the witnesses were there and they were thrashed, they could hear the sounds. There's nothing. It just says that they were outside, they could not see anything, and only you said that Robertson Marak, he just slapped the back of the head. Correct.
Lordship.
And you have not made party the other. You said that then there's a woman.
That I make a party to women, but only the
woman you made only for that the one who filed FIR against you, your alleged girlfriend, not against the other police officer.
No, other police officer I don't make personal, but only.
Right? But they said that she's the main perpetrator who assaulted you, according to you, in that investigation report.
Because that investigation is done by the SID Rani. It is not
correct.
But it's not
See,
by.
you don't understand what this court is trying to say.
Yes.
You see, we go by the injury report, investigation status report. It's done by the Rani, whoever she is. Correct.
That's it.
See, the thing is that in your complaint also before the court below, the IO was called also to inquire into the incident. Correct?
Yes.
So due to every court also, whenever accused or under trial is produced, to first ask about the well-being of the under trial and to see his physical condition, whether he's been treated well or whether been. Now, there's nothing, only says that you to ensure the safety of the arrestee at all times.
Yes, Lordship.
But then nothing could be seen that police assaulted you on 10/8/2023.
Lordship, there is that.
But if you just slap, also nothing will show an injury report.
Yes,
By your own admission, you said that he slapped the back of your head. Correct.
But
once.
Yes, but they're not. The private respondent 5 is not denying the fact that he has come and he has uttered. May not, as I said earlier, that there must not be so serious.
Why has come? Explain para 7 of his affidavit. Okay, see para 7.
Lordship can be disputed, but there should be some observation against the manner in the how the men in uniform should function, because it is a prima facie case that he has come. Actually, they are not, even in their affidavit they have stated he come to
Suppose you have treated this poor lady this way, you think you deserve any sympathy from anyone?
Lordship.
You've treated that poor spot number 6, who's stated to be a girlfriend, in such a shoddy manner. So the same treatment you give to others, you will get from others also. You assaulted that person. took away all the
That,
certificates.
Lordship, because that is only an allegation that the court will try, because that
you
is
have the bite mark to prove it also. That there
because
was
that even in the trial court I am denying this statement, because that is the FIR against me. Just filing the FIR against me it's not mean that it's been that I'm proven guilty. That I will face the trial, but I'm denying the fact also. But I'm not. This is
see Aramail police station. He's post Aramail, correct?
Yes.
So once FIR to Aramail is sent to the women PS in Tura, the women's police station in Tura. Because anyway, take down. The writ petitioner is before this court with a complaint of excessive use of force by the police in connection with his arrest. In which case is it? In
case number. Case number, Your Lordship. In 62, bracket 8, 23.
Tura women.
Lordship will find at page 2 of paragraph 6 of the state affidavit, Your Lordship. Paragraph 6 at page 2, Your Lordship.
What it is in Tura women PS capital CS number 79/2023.
That is the short sheet, Your
sorry.
Lordship. That is the short sheet. It
Where's
has
the
been
case
short
number?
sheeted, Your Lordship. Lordship will the detailed report, Lordship, below that PSCS number, Your Lordship. The detailed report submitted by the investigating officer of Tura.
One second. Oh yes, sorry. Tura PS case number. Tura women PS case number 62.
Lordship.
Bracket 08/2023 under sections 448/323/509/376/506. Stop.
It has been charge sheeted, Your Lordship. That is there.
Which has since been charge sheeted.
Lordship, PSCS 79/23.
And the writ petitioner also obtained bail in the meantime. Stop. Next paragraph. Mr. P.T. Sangma, Learned Counsel for the petitioner, submits that on an FIR filed by the prior respondent number 6, the writ petitioner where is this? You went yourself to police station?
Yes.
Who then had gone to the Tura women police station, was assaulted by police personnel.
Lordship.
Especially by the prior respondent number 5, 13 Robertson K. Marak. Stop. The Learned Counsel submits that after being beaten up, he was taken to hospital for medical treatment. And in spite of his complaints against the actions of the police authorities, no action has been forthcoming, which has compelled him to come before this court by way of the instant writ petition. Stop. Next by Mr. N.D. Shulai, the AAG with so-and-so for the respondents number 1 to 4 have filed an affidavit that 1 to 4 has relied upon the affidavit filed by the respondents on their behalf by respondent number 2, wherein the FIR filed by the respondent number 6 with regard to the actions of the writ petitioner for which the case had been registered, as also lists of witnesses, and an investigation status report. Stop. It is submitted that as per the investigation status report, the statements of the complainants were together with the writ petitioner were recorded under section 161 CRPC, and from the statements so recorded, the witnesses did not see with their eyes, were not witness to the assault as they were outside the Tura Women PS. Stop. It is further submitted that from the injury report submitted and filed before this injury report of the medical and health officer of Tura Civil Hospital, the injuries sustained by the writ petitioner are bite marks, and there's no sign of any aggravated assault by police personnel. Stop. It therefore submits that the writ petitioner, having not been able to substantiate the allegation of the violence committed by the police officers, the writ petition is without any basis. Stop. Mr. K.S. Kinjing, that paragraph, Leonard Senior Counsel with so-and-so appearing for the respondent number 5. As also stated in affidavit, has refuted the statements of the writ petitioner that he, not being an officer of Women's PS, had entered the said police station and assaulted the writ petitioner. Stop. It is submitted that the FIR by the respondent number 6 had been filed on 9/8/2023 before the officer in charge of Aramail Beat House, West Garo Hills, and the same had been received and a GT entry made. Whereafter, the same was forwarded to the officer in charge of the Tura Women's Police Station. He further submits that he also supports submissions made by the London AAG, N.D. Shulai, and submits that no case has been made out by the writ petitioner to warrant any directions. Next paragraph. Having heard the counsel of the parties, and from the materials as produced, it appears that from the produced, it is seen that an FIR was lodged by the respondent number 6, who was stated to be, I will not put that, but from the 6 against the writ petitioner of physical assault and also of other action by which cause physical suffering to the respond number 6. Stamp. On this FIR, it appears a case was registered and the writ petitioner. Were you arrested and brought to the station or you went by yourself?
No, he surrendered, Your Lordship.
By the petitioner, then surrendered and went to police station. Where it has been submitted, the assault occurred. Stop. From the injury report and from the other investigations report, apart from other materials have been produced, no tangible substance, no tangible material has been given, has been produced to substantiate the fact that the writ petitioner was subject to assault by the police force. Where is that before the court you produce?
This,
the finding of the magistrate?
That is on page 24.
Page?
Page 24, affidavit 5 of the state respondent, para 8. Para 8, page 24. The paragraph 8 is there. They have mentioned.
Yes, from now? Further, it is seen that when the writ petition is produced before the judicial magistrate on 11/8/2023, he had informed the court about the assault, for which the court had then summoned the IO, had then called the IO in charge of the investigation for explanation. And on receiving the explanation from the said IO, the court had passed an order on 14/8/2023 with direction to I to ensure the safety of the arrestee, but had also observed that there was no clue or any or no clue could be no clue be commended, that no clue could be seen that the police did assault the writ petitioner on 10/8/2023. Stop. Next paragraph. Accordingly, on the basis of these, accordingly, in view of the scanty materials available, on behalf of the petitioner. Accordingly, in view of the inadequacy of the materials to substantiate or the nature of injuries to show that the petitioner had been assaulted by the police while being arrested in connection with the said case, this court at this stage will not issue any orders. Cannot accede to the prayer made by the petitioner for what is your prayer? For action to be taken against respondent number 5.
Prayer is at page 12.
Yes, 5. As much as observed earlier, no materials exist to show that the petitioner had been subjected to physical assault. However, to make it clear that such matters, the respondents, especially the men in uniform, are to abide by set procedures in such matters and not resort to physical violence. Stop. When any other trials in the custody. For the foregoing reasons, and for the foregoing discussion, the petition is closed and disposed of. Yes.
Apply, Your
Lordship. Item number 7.
Made to Your Lordship.
Yes.
My Lord, in terms of Your Lordship's last order, respondent number 6 correct address was to be furnished, my Lord.
Yes.
My Lord, in pursuance to my Lord order, my friend has taken steps with the registry, furnishing the details of the respondent number 6. But registry advised us to get some more clarification from my Lord.
Who's respondent number 6?
Now,
Excuse me.
it is the NCTE, my Lord. Earlier we did not mention the officer who can receive the notice.
What's matter about is that?
It is appointment of primary teachers.
My Lord,
NCT would be represented by the chairperson.
Yes, Mr.
My Lord, the writ was for prayer in the writ petition, my Lord, was relating to interview which has already taken place. If I can show, my Lord, the prayer, possibly in my submission, my Lord, the writ has become infructuous. There is another writ petition filed by a set of petitioners challenging the appointment on the ground that the respondents are having 18 months of diploma, my Lord. Kindly see the prayer 21, my Lord, page 21 of the writ petition.
Yes.
And the prayer is, my Lord, the impugned final select list notice dated 11 December 2023 with regard to private respondent number 7 to 19 and other similarly situated shortlisted both ST and unreserved candidates who has 18 months obtained from NIS and direct the respondent to prepare a fresh list of qualified candidates including writ petitioner for interview by excluding the name of private respondents and other similarly situated persons. Situated shortlisted candidates. My Lord, under the impugned notice dated 11 December 2023, who has 18 months of DELED obtained, my Lord. So the prayer was, my Lord, was for cancellation of interview. Interview has already taken place, appointment has already been made of the petitioner. So substantive writ petition has to be filed. What has happened, my Lord, that there was a miscellaneous application filed by the petitioner, my Lord. In miscellaneous application, Lordship has passed the order. That order, my Lord, is also, if I can place that order, your Lordship will see that order of miscellaneous application, my Lord. That order, your Lordship has said that the appointment will be subject to outcome of the, that is the order passed on, my Lord, 19th January 2024, my Lord. And in that order, your Lordship has passed the order stating that the appointment will be subject to outcome of the writ petition. Paragraph 9, if your Lordship kindly see the order of your Lordship of in the miscellaneous application.
Yes.
That is 19 January 2024.
Yes.
Now paragraph 9.
Long order. Yes.
Miscellaneous application. However, as regard the case of petitioner and the relevant portion of notice, that is those selected candidates falling under the unreserved category who have been specifically arrayed as party respondent in the main case at all, and any appointment issued to them, such appointment would be subject to the outcome of the writ petition.
Yes.
Now, the issue which calls for your Lordship's consideration is that in the main writ petition, my Lord, the challenge was limited to holding up of the interview, my Lord.
Yes. Or it's not
and in the miscellaneous application, the order came to be passed, my Lord, stating that the appointment of only unreserved candidates will be subject to outcome, because if there is a
the interview has already been held, that means this writ petition you already filed a different one. You already filed a new one.
No.
Challenging the appointment.
My Lord, we did not.
You cannot. Why?
What happened, my lord, during the shortlisted candidates was published. We challenged that one, saying that those candidates they did not have the requisite qualifications.
Now the interview is over.
My lord, and my lord, we pray for restraining the respondent authority not to conduct the interview. Lordship did not pass that order, and the interview proceeded, and the interview concluded. And when they conclude the interview, they proposed to publish the select list, final select list and appointment. We came before this honorable court by filing a missed case, restraining the my lord appointment of the new selectees. Now, because of that, my lord, lordship, this honorable court has passed this order, making very clear that the appointment of those respondents would be subject to the outcome of the writ petition. So, according to me, my lord, in that view of the matter,
no,
it is not required to file.
No, the thing is that now the new appointment orders have been issued. Then the consequential orders.
Yes, my lord.
The consequential orders, whatever it is subject to petition, they have to be challenged also.
My lord, according to me, my humble submission, my lord, if lordship satisfy my argument that once the foundation of the selection, the eligibility of those candidates is gone, my lord, the interview, consequential action of interview will also go.
We understand that. Then you bring on record those things. Meanwhile, those appointment orders.
Appointment order. I'll obtain, ma'am.
Then we'll hear it, Mr.
Yes,
Advocate General.
Yes, so Lordship, writ has to be amended. My prayer was, writ petition has to be amended.
Prayer, that's their lookout. If they don't challenge consequential orders, it
If
just
there is
takes us
no,
down.
so then therefore,
Yes.
This is the correct address.
It is the correct address, but to be received by chairperson, my lord.
Yes.
Lordship allow us to make necessary correction. Respond number 6, my lord.
Yes,
Page
today, Mr. H. Zareso, Learned Senior Counsel has furnished the correct address of the respond number 6.
Well,
registry to make necessary correction. Steps will be taken upon number 6 within 2 days.
Yes.
Just a matter of 3 weeks. Yes.
My lord, with lordship permission, I may pray one more. My lord, respond number 7, my lord, 8, 11, 14 and 15 may be strike off because, my lord, they were selected for interview, but they did not get selected.
7?
My lord, 7, 8, 11, 14 and 15.
7, 11?
7, 8, 11, 14.
Yes. 14 is struck off, yes.
And 15, my lord.
And 15.
And 15. Some were not selected, some were appointed in different.
Yes, as far as submitted that as respondents number 7, 8, and 15.
11,
7, 8, 11, 15 are no longer in contention. The name is struck off from this array of parties. Registry to make necessary correction, strike off the parties, yes. Just
Highly
after 2 weeks, yes.
Highly obliged.
When are you coming back, Mr. Advocate General?
after 10 days, my lord. After 10 days.
Which
By
city are you in? Which
I'm
city?
New York, my lord.
In New York? Well,
New York, my lord.
not so far away. It's not very far difference. Yes.
Item number 8.
Excuse me. I want a tissue.
It's a contempt petition, my lord.
Tissue paper.
The contemptor is supposed to demarcate the land, but they haven't filed
Please,
affidavit.
Your Lordship, I believe paid 2 weeks' time, Your Lordship, to file the affidavit.
The amount of time they're taking, my lord, if you could
Because
just
we could not
demarcate, my
receive
lord.
the instruction, Your Lordship.
What happened? They don't know it's a contempt.
They know, Your Lordship, but they haven't produced us the instruction, Your Lordship. We haven't received till now, Your Lordship. So we need some more time, Your Lordship.
1 week for a time.
2 weeks, Your Lordship, last.
Okay, 2 weeks since, yes. For the time has prayed.
Much obliged, Lordship.
9.
Made pleasure.
Yes. Apa yang 9 say?
9, lord. Time has been sought.
We have
But,
short time to file the affidavit, Lordship. In fact, the affidavit is ready. Only the difficulty is, Lordship.
Okay, in the course of the day.
Lordship,
In the course of the day.
Lordship, only thing is like he's out of station, Lordship. He's in Bangalore due to some family emergency, Lordship. So sometime maybe, Lordship, I'm praying.
1 week for the time granted. Yes.
10.
Lord, in this case, respondent number 8, my lord, notice we have sent already. I'll take the status report, my lord, from the post office.
Number 8 whom?
Respondent number 8.
Number 8 whom? Not received back. Office note indicates that the notice on economy is not complete. Stop and second, praise for allowed 1 week time to obtain this report and to file. So after thereafter. Yeah.
After 2 weeks,
Yes, after 2 weeks.
11.
Please, Your Lordship. Lordship, in compliance of this Honourable High Court order, my Lord, we have furnished a copy to the concerned officer, my Lord.
What happened?
Thereafter,
The matter can be disposed of, my lord.
Resolved.
My lord, with a certain time frame, we'll do it, my lord. The requesting for 3 months, my lord, and they should cooperate, my lord. There's nothing. We'll resolve it.
they are willing to cooperate, my Lord.
You've given this to Mr. Moomin?
No, no.
Yes, communication dated 25/2024. 20? Yesterday only?
Yesterday.
Has been produced by the learned DSGI, wherein it is stated that 3 months' time is required to process the case of the petitioner, as much as some original passbooks are under custody of the respondents. Given 3 months, yes. In view of this development, this AG movement, who's also been sent a copy of the letter, submits that the matter can be closed at this stage. Yes. Hotel Musica to next vendor is also directed to ensure that the dues of the petitioner are paid at the earliest.
The respondents.
Hmm?
The respondent to ensure.
Oh yes, it's also directed to to ensure that the respondents, we're binding you personally, ensure that the dues of the petitioner are paid within the period of 3 months. Stop. Next one, petitioner opening stands is disposed of, giving the response 3 months time from today to settle the dues as claimed by the petitioner. Stop. The liberty is also next to the petitioner to oppose this court in the event these directions not complied with.
Highly obliged, my Lord.
Item number 12.
May it please your Lordship. Lordship, so for the state
Affidavit?
response, Lordship, we need some more time, your Lordship. We are yet to file the affidavit.
What about service on the other respondents? 9, 11, 13, 15, 19, and 2023 not been received.
We are yet to take step also, your Lordship.
Well, taken steps. Yes, Mr. Enishulai landed AEG is also praised for the allowed how much time?
Let it be 3 weeks, your
3
Lordship.
weeks for the time to file affidavit. Stop. Next office in the next first note also indicates that the service report on behalf of respondents number 9, 11, 13, 15 to 19, and 2023 has also not been received.
Lordship, let the interim order shall continue. Interim order shall continue.
Yes, this is interim order shall continue meanwhile. Yes.
Apply.
13.
This for affidavit, madam. I'm praying for some more time.
Yes. Yes, second time has come.
Second time.
Yes, 3 weeks further time has prayed allowed to the response file affidavit.
Hearing. Supplementary list. Item 16.
We'll close this, Mr. Gautam.
My lord.
So there is a notification dated 13 May.
Because by first there will be new officer. Mr. K. Sukutam submits that due to other developments, and this transposition may be allowed to be withdrawn and closed. Yes.
Apply, Your Lordship.
Unfortunately, the matter is disposed of as withdrawn.
Much obliged.
Daily list 14.
Examine the inquiry
My
report.
Lord, on the last occasion, there was a submission from the petitioner that he was not aware of the meeting. He was not called for the meeting. My Lord, to that submission, my Lord, I have a copy of those documents in which he was given the copy. He refused to come. The
You made
Dorbar,
notes.
my Lord, yes. Those are the documents, my Lord. The first page is with regard to the Dorbar Rangbashnong, my Lord. He writes a letter to us saying that Mr. Strictly Samely refused to accept.
Yes.
He refused to accept, and which is why he verbally, so my Lord, regarding the inquiry, he was away, so the Rangbashnong has to return and write this letter to us. And my Lord, the last page of the document which I have given, the last page is a WhatsApp group, my Lord, of the school. So basically in the WhatsApp group also regarding the inquiry, this was also informed, my Lord, to all the members of the school authorities, my Lord. And my Lord, if I take Lordship attention to the second and the third document, my Lord, he was very much aware of the inquiry and he was called, but he chose not to come, but he writes a complaint to the subdivision officer and the director, saying various reasons, my Lord, that the officers who have been assigned to conduct the inquiry are not the competent officers and other reasons, my Lord. And my Lord, even in that letter, I have also enclosed the attendance sheet. And in the attendance sheet, my Lord, serial number 6 is his son.
And Saibor.
My Lord, his son. So basically, my Lord, he was aware of the meeting was called, and the outcome of the meeting, as Lordship has heard on the last occasion, was very much aware of the outcome of the meeting also, my Lord. So, my Lord, inquiry was conducted as per Lordship's direction, my Lord. And number 9, my Lord, 6 and 9 are his son. So, my
Very
Lord,
slippery customer, Mr. Charisco.
My Lord, I pray for furnishing copy from my friend
Let us find an affidavit.
and give a short
Then we'll close
response.
it next date.
my Lord, we will be filing affidavit with regard to this particular
Only
document.
documents are what is
Only
attendance
this
and
document,
party.
my Lord.
Yes, MS Arconi produced set of documents evidencing the fact that the petitioner was well aware of the inquiry, but had voluntarily stayed away. That she is permitted to file the same way affidavit, but copy the other side. This is the same after 1 week or 2 weeks for final disposal. Innings is over now.
And Lordship, allow us to give a response after receiving.
I
That's
was
up to you.
praying this matter should be disposed of. The petitioner is using this High Court for his own personal
Not at
benefits,
all.
my
I don't
Lord.
want to enter
The
to
inquiry
argue
report
on the
also
merits of the
clearly
case.
shows what were he doing in the school.
There was no problem. There was no inquiry. I'll give a response.
Very much, there was none.
Obliged.
22.
Go for appeal. Yes. Where's Mrs. Sen?
Lordship, my calculation is ready, Lordship.
Simplified calculation you given.
Give me, Lordship.
Give it to them and we'll dispose of the matter next date. You go to the court and give a copy to them and we'll dispose of the matter next date. Listen, just examine, we'll dispose it on the next date. We'll not keep it pending any longer. Simplified calculations as directed by this court have been filed by the legal counsel for the respondents. A copy is also made over to the counsel petitioner. This is matter after 1 week. Next date, on the next date, the matter shall-
This is the calculation. Now the question, only the moot question is here, my lord. Escape amount, my lord. There is a period of limitation. Can it be reopened?
No, that will dispose next date. We will.
My lordship will hear on.
We'll hear, of course. Only that we've seen.
Yes. But that is the only
only
question.
the calculation part
Yes,
you have to clarify this on.
All right.
So we'll examine this.
All right.
The matter will be expected. Endeavour shall meet to dispose the matter on the next date. You've got a copy?
Yes, my lord. I'll go.
You examine it and then.
26.
Yes, Mr. Nongpui.
Please, Your Lordship, I'm not accepting the proposal raised by the learned senior. May I take Your Lordship to my rejoinder first, my Lord?
Mostly.
Because they...
Rejoinder?
Yes, Lordship. Page 25, Lordship.
Page 25, rejoinder.
Para 16, my lord.
Yes.
Read out, Lordship, that the respondent had misled his Honourable Court that the petitioner is working only till February 2022. However, the actual position is that the petitioner is still working even in the year 2023, where the division still allot works to the petitioner, which is clearly to state that the department still reposes trust, confidence, and dependence and reliance on the petitioner, in which the workload would hinder the functioning of the department. Hence, the post of the petitioner ceased to exist even after February 2022 and 2023 onwards, Lordship. So, on the last occasion, they stated that we are not working, Lordship. Back wages not entitled, Lordship. May I just take your Lordship again to page 40, Lordship, in one letter.
Page
40, Lordship. Yes, Lordship. With reference to the subject cited above, as per your verbal instruction, I have the honour to bring to your kind notice that 12 numbers of sectional assistants mentioned annexed to 1 are still rendering a satisfactory service till date, which is to the utmost satisfaction of all superior, despite the salaries being withheld from the month of March 2022 till date, Lordship. So this is clearly stated that we are continuously working, Lordship. Therefore, back wages we are duly entitled, Lordship. Because our salary was stopped since March 2022.
This is 15, 12, 23.
22. Lordship. And we are continuously working even till date, Lordship. Without pay, Lordship.
What does the matter last heard?
On the last occasions, I have produced
On the last
one
occasion, Your
Supreme
Lordship,
Court
when
order,
I had
Lordship.
come up with a proposal that the government would like to regularize them, but without back wages, then he was only asked to find out whether his party, petitioners would
why
be
you want back
interested.
wages? You take.
They have not been working, Your
I
Lordship.
have been working, Lordship.
No, Your
Yes,
Lordship.
I'll accept the regularization, Lordship. And
Pursuant
back wages
to the
also we are.
You have to give and
In
take.
any case, Your Lordship, they were not entitled. It
we
is
are
because
working
by
without
wrongly
pay,
or
then,
rightly,
Lordship.
it was forwarded
That's
to the
a gross
cabinet for their
discrimination to
approval.
us, Lordship. And I'll just point out new
You
development.
an exception for you.
Lordship, there's a new development that
We can't have new developments all
No
the time.
developments, we brings out paper which we don't even
No,
have.
Lordship, I just want to produce this, Lordship.
Yes.
Because, Your Lordship, they were serving in a work-charged regularized post, which was supposed to lapse at the time those original incumbents retire or
So this is the resanctioned
die.
post, Lordship. 13 lapse posts in the Public Works Department, Lordship.
Then wrongly or rightly, their tenure was extended, and their names were forwarded to the cabinet.
This concerns you.
Yes, Lordship. My name is included, Lordship.
In this one?
Yes, Lordship.
Resanctioned?
Yes, Lordship.
You seen this one?
No, Your Lordship, I have not seen anything.
This is like pulling out the.
And the cabinet decision
from
also.
The rabbit from magician's hat.
Yes, every day, Your Lordship, I find my friend brings up
No, you see,
something.
this is very interesting. Let's have a look. See, this is resanctioned lapsed post authorization appointed prior to 2007. Going to be sanctioned of government area to 13 now lap posts created by PLB administration so and so.
It's already
You
concurred.
given a copy?
I've given them, Lordship. They are already concurred from the Finance and the Personal Department, Lordship.
This is 24th February, 28th February. That just
This is more or less
I would like to enlighten
the
further,
resanction of this post is in line with the cabinet approval for regularization to ad hoc employees appointed prior to 2007, as communicated. But we are not able to implement the government-led order, Your Lordship, because of the matter pending before this Honourable Court. Which is why on the last occasion, Your Lordship, I had pointed out that the government is ready.
They will create the post again for you.
Just for them. It will be personal to them.
Yes. But no back salary.
I would like to enlighten further, Lordship. There are 13 Lordship employees as per this resanctioned Lordship.
How many petitioners are here?
Pardon, Lordship?
How many petitioners is just?
There are 2 petitioners, Your Lordship.
However, out of this, from the 13 list, Lordship, all the 11 of them, they received a salary.
No, because they have accepted the alternative.
No, Lordship. Despite
Alternative
the post-lapse,
employment on contractual basis, Your
ad hoc
Lordship.
employees, Lordship.
Now we are also afraid, Your Lordship, that these contractual employees may also come. If we give it to them.
You take it.
They take it or leave it, Your
We are
Lordship.
not dwelling on that contractual employees, Lordship. What
Either
happened
they
is that
take it or leave
I would like
it.
to produce some documents, Lordship. All the 11 of them, the salaries were never being withheld, Lordship. Despite the cabinet meeting 15 March 2022, recommending to regularize, Lordship, all the ad hoc employees.
Which is why we have agreed to this, Your Lordship. Otherwise, they were in the first place, they were not entitled at all. Ordinarily, they have been appointed on ad hoc basis without following the due process of recruitment.
Lordship.
And so many other illegal and irregular things happen to the department,
like
which
to
we are not
produce-
bringing to Your Lordships. And
Yes. No, purely we know what's happening. Yes.
I want to produce statement salary that these 11 of them they received, Lordship.
they are on contractual basis, Your Lordship. We have admitted that.
Now you
9
do
of
one thing. Wait just your prayer.
Because then there'll be no end to this case. Either they take it or leave it, Your Lordship.
No, that's up to the court.
I mean, of course, Your Lordship, you're aware of that. They have passed for grant regularization, but there's no section assist against sanction post.
Yes.
Release is
okay,
being withheld.
take down then. Take down. We'll dispose of the matter now. One order we can dispose both the cases. There are 2 cases, correct?
2 petitioners, Lordship.
Yes. The next matter same.
Item 27, sir.
Your Lordship, the rest of the 11 people who he has been mentioning, Your Lordship, they have accepted the alternative.
No, but are they being paid the back wages?
Yes,
No,
Lordship.
we have
Lordship,
alternative
I-
employment,
that's why,
so they have
Lordship, I
been
want to
paid.
produce this statement, Lordship. They received a salary, Lordship.
See, but then
since March 2022, they received, even till 2024 also they received. Why not us, Lordship?
Where is written?
This one, at para 7 of our affidavit, Your Lordship, we have said that on humanitarian grounds, we have made arrangement for alternative employment to revert all the incumbents appointed as section assistants in the year 2001 to the post of contractual appointment. And these 9 of them have accepted it, Your Lordship.
No, Your Lordship.
And they've also given an undertaking letters, which we have enclosed, Your Lordship, as Annexure 7, 8, and 9 in our affidavit.
Yes. The one that my learned senior reads out refers only to my division that I'm working, Lordship. Whereas in this 13 list, Lordship, it refers to other divisions, Lordship, in Umsning, Jowai, Shillong, Barangapara, and Nongpor, Lordship.
They are not before this court, Your Lordship.
And even the names were included in the cabinet list, Lordship.
But we are only confined to this case, Your Lordship. Our affidavit in opposition, Your Lordship, may kindly see.
Now, out of 12 people, 9 people accepted straight away.
They have given an undertaking also to
What
that.
happened is that what my learned senior raised is that it falls only under my division that I'm working.
But we have-
that is the
we are
National
before
Highway
this
Shillong
division.
Bypass Division. Whereas in the 13 lapse post, resanctioned post, it talks about all the other employees from other divisions, Lordship, from Umsning,
If there are
Jowai,
13,
Nongpor,
then these are the 13.
Barangapara, and Jowai, Lordship.
If there are 13
Yeah,
posts, Your
resanction,
Lordship,
Lordship. All these are
originally
ad hoc
13
employees
posts
and
were,
post-lapse, Lordship.
I think I'm afraid, Ms. Nampur, we have to be
because those
satisfied.
13 are
let them
nowhere in
consider
this list,
if
in
we
this
can,
case.
If from the records of the department that you've been working regularly, then if it shows, then they will consider it. Otherwise, we cannot pass orders here on the basis of the letter when EE saying they've been working. They have to be substantive records. What
Lordship,
work you assigned with, what were you doing, all those things should be there. Because you cannot just be say I'm working and then you have a friendly executive engineer.
Yes,
will just,
that is what has
happens on
happened.
his
They were
part, just
going
say, "Oh,
regularly."
He's been working, he's diligent.
Yes, correct.
And then there creates a lot of problems for the department.
Otherwise, this, whoever issued that letter can file an affidavit also.
Yes, Lordship, working without pay.
No, they have not been working, Your Lordship.
Which is totally discrimination,
No,
Lordship,
no.
against
Why
us,
were you
Lordship.
working from 2022
No,
without
Lordship,
pay?
I have one judgment also, Lordship.
Yes. Raman.
No, Lordship, the other one, Lordship.
No work, no pay.
No, Lordship. I would like to place this.
Can I have a copy of that, please?
Based on the principle of parity, Lordship.
Rajasthan.
Lordship, this judgment, though it does not slightly refers to this matter, deals with the promotion matter, Lordship.
This is another High Court single
Lordship,
bench.
my contention is that if the other employees, based on the same footing, Lordship, we all ad hoc employees, Lordship, after found out by after the cabinet meeting regularization, Lordship, post was lapsed, Lordship. Why is it that these employees, other employees, receive the salary and why not us, Lordship? That's
You recover salaries from other ones.
That's the only
then,
condition.
then you cannot seek negative equality.
No, my lord.
If it's wrongly given to them, then you cannot seek negative equality.
Given, Lordship.
If it's given to them, if they're not working, like they say, then you can't seek negative equality. If some wrong is given to them, like the wrong should be inflicted on you also, then we'll direct also that whether not parties, that in cases where they've been paid wrongly to ensure parity with you, they should recover salaries from the pay that they're going to draw. If that'll bring about equity.
Oh,
if you want similar treatment,
yes,
now what offering is that fine? See that your case is, why is your case difficult? Because your point extension was against both at a lapse, and they continued, and now at least the respondents are making a concession that okay, fine, we will regularize you against these posts which are created again, re-sanctioned just for your purpose.
Personal
so you
to
for
them.
personal, and like all other, when you retire, these posts also will die with you.
Cease to exist.
Okay, that's the thing. Now, if you see that other people have been paid wrongly and they were similarly situated, that means this court cannot direct for payment to be made if the factum of your working is not established beyond doubt. Now, and without any orders of any authority. Now, the thing is that then they also should be subject to recovery proceedings by the finance department, whatever, from the salary that they have drawn the salary for 1 year, it should be recovered, accordingly. To ensure parity with you. And since you have not been, you also have not been paid, they should recover the salary. That's the thing, because we can't plead negative equality. Suppose wrongly is been given, doesn't mean that a wrong is perpetuated. That again, the departments the way we're working, I don't understand. If that's a submission that you paid, how many of them have been paid money?
These 9 people, Your Lordship, who have accepted contractual employment.
They were paid back wages.
Contractual, fixed pay, Your Lordship, and they have taken.
Contractual.
Yes, from Annexure 7, 8,
What
and
they accepted 2022 itself.
yes, Your Lordship, they accepted without coming.
June 22.
But Lordship, that's the
See, basic 36.
These are from other divisions, Lordship, whose post has been lapsed, Lordship.
Atrisha Marwin, I think she's also petitioner somewhere, no?
No, Lordship, they are not petitioners, Lordship, but I'm just producing, Lordship, because we all falls on the same footing, Lordship.
In 2022 December, Your Lordship, they accepted. So they have been being paid their salary, Your Lordship. And their undertaking is also there, Your Lordship, Annexure 6, 7, and 8. 7, 8, and 9, Your Lordship.
No, Your Lordship.
Where's the others appoint orders? Is it here?
Your Lordship, those employees raised by my senior Lordship, they were not even recommended by the Cabinet, Lordship. That's the first thing.
They were not recommended by the cabinet, Lordship.
We don't. Are they there before the court?
No, they are not before
Then?
the court.
Yeah, the court, but
You are? You and this Lumlang Binong Sage.
Lumlang
There are two of
Binong
them.
Sage.
That means your board's SAs, your appointments also.
In 2001, they were appointed. Your Lordship.
The writ petitioner was appointed. The brief fact of the case is that the writ petitioner was appointed as a sectional assistant on 31/7/2021. Under the NH National Highway, NH Long Bypass Division. Allegedly against, purportedly against a sanction post. Stop the services of the petitioner was allowed to continue. Till when? Till March. You extended from time to time.
we are extended even till their Lordship.
I'm not so I'd like to know on extensions. Till where's the letter? Till March 2022.
February, Lordship.
Till February 22. When when the salary was withheld for 9 months from March to November 22. Further
If I may interrupt
facts are
you,
relevant are that, yes,
Your Lordship, in paragraph 4 of our affidavit, you've stated clearly that their services were not retained anymore, Your Lordship, after
no,
that
that's
period.
the brief fact of his case.
Achha, okay.
Yes, problem
Take care.
on various restrictions.
Was withheld.
For 9 months, from 22 stop. Thereafter, the salaries were no longer paid. Which has caused the writ petitioner to approach this court to seek appropriate orders for payment of back salary and for realization of his services, as it is to stop. Next para, Mr. Sunsun Hongpure, the writ counsel with petitioner, has submitted that the writ petitioner was appointed against a sanction post, and as such, the decision of the respondents in November 2020, where is that your work charge? When was that?
August 2000.
Lordship, there's a letter.
To treat them as work charged was totally unjustified. He submits that the writ petitioner has been working for the past 21 years, rendered 21 years service, and as such, consideration should have been given to long years of service, and that if regularized, and that he should be paid. The petitioner should be paid for the entire period for which he has rendered service. Reliance has been placed by the Learned Counsel on a certificate issued by where that he been working. That's the rejoinder.
My rejoinder.
Yes, has been relied upon by the counsel for the petitioner. Come now. The petitioner on this rejoinder affidavit, wherein at annexure
page 40, Lordship.
Page 40.
Yes, Lordship.
Wherein annexure 4 thereof, a letter dated 15/12/2022 has been enclosed. Requesting the Chief Engineer Police Roads to take up the matter regarding their reappointment contractual basis, and that they've been rendering satisfactory service till date. At this juncture, it is relevant to note that in the course of the proceedings, the writ petitioner has been offered by the respondents to be regularized, albeit without back wages, if any. Stop. This offer is based on the premise that the writ petitioners were never appointed against a sanction post. Writ petitioners were appointed inasmuch as the posts to which they were appointed had lapsed with the retirement of the earlier incumbent, and their continuance service was affected by executive orders passed within the department.
Within the department, Your Lordship.
Stop. It is also to be noted that the cabinet is meeting held on
February 2022, Your Lordship.
On February
15 March.
15 March 2022.
Had passed a decision with regard to the regularization of employees who were appointed, ad hoc employees who were appointed
prior to 2007.
And it is in this backdrop that the writ petitioners have been offered the regularization to the posts to which they are occupying, stuff. MSD Yangi has also submitted that
To the post they were occupying, Your Lordship, we are only saying that we
Regularization,
will
okay.
for regularization.
Yes, Mr. MSD Yangi, learned EAG, has submitted that. The appointments given the year 2001 of second assistants were not against vacancies but against regularized work charge posts, which had since lapsed, and the set posts the set post was not retained, inasmuch as the same had been created particularly for the pension benefits of work charge employees. However,
Working prior to 1993, Your Lordship.
Yes,
as per that order dated 1999.
anyway, as such, she submits the petitioner being appointed in the year 2001 was to a non-sanctioned post, and it cannot be taken. No, it's a non-sanctioned post. Non-sanctioned post. It's a non-sanctioned post. Stop. However, she submits in consideration of the fact that the incumbents, the petitioner have been working for a long time. He has been offered, along with other similarly situated
employees, work charged employees,
to opt for contractual appointment.
Right.
On?
In December 2022,
December
Your Lordship.
2022. 22? 22. In December 22, which was refused by the writ petitioner. You refuse it?
I refuse.
Or was accepted
Both the
by,
writ petitioners have
by the writ petitioner, will I say, or was ever accepted by how many of them are there?
9 of them
9
accepted
other
it.
employees, similar situated employees. It is further submitted that notwithstanding the refusal of the writ petitioner to revert to appointment under to revert to contractual appointment, stop, the writ petitioners at this stage are at liberty, or what will be the word to use? The petitioners are free to, not free, are.
May I interrupt, Lordship?
Yes.
On the last occasion, I have produced that Supreme Court order, Lordship, where there is discrimination if they are not regularized as Lordship. So I would like to regularize with effect from the same date the other employees were regularized. This is 26/10.
From the date of order, Your Lordship. It should be from the date of the
As per
order.
the Supreme Court order, they should be regularized from the
Not
date.
regularized as per the cabinet decision from the date of appointment, correct?
Yes, it should be from the date. That is the condition, Your Lordship. The cabinet approval gives that. Certain conditions were there, and that is one of them, Your Lordship.
Yes. Actually, because the cabinet said against sanctioned posts only. Now, what happens that you're not appointing a sanctioned post, you're ad hoc, there's only a post that lapsed. That's why regularization now they'll examine it.
Yes.
Because it's not contractual now, it'll be regularized. Correct. Now, what relevance does letter have 28 February? 13 posts lapsed, but they don't indicate the nature of posts.
Where is that, 28 February?
Anyway, farmer.
Oh, this is...
again, given the option to accept the offer of regularization, though without any claim for back wages, or without any back wages for the period that they were not paid. For a period that
They
they
were
have,
not-
stated
have
that
not rendered any
they have not rendered
service.
any service.
My lord,
Mr. L. J. Nongpur at this stage has submitted that if the petitioner is to accept the proposal as given by the respondent for regularization, the same should be from the date of initial appointment. Correct? In the said post. What do you have to say to that?
Lordship, pertaining to the back wages, Lordship, again, in my rejoinder, I had attached sample of works that I'm doing, Lordship, which proves that I am working, Lordship.
It's not getting anywhere. See, the only thing, the long and short of it is that, you see, the thing is...
Is this rejoinder?
The base, because everything stems from your appointment, you're right. They flow from there. Now, if your appointment was wrong, I'm not going to record an order that erroneous appointment was made to you against a post that doesn't exist. Now, that will involve other action against people who did it. It goes too long back. Now, erroneous appointment was done. Okay, you will not say illegal, but irregular appointment. Now, irregular appointment, how do you reconcile irregular appointment so that you be given due benefits as you're due to get? But benefits doesn't mean put the same footing as people who are who are appointed normally but
Through the
derive
normal
the service
course of
benefits,
selection.
entitlements. You have to understand that. That's service jurisprudence. You understand? Because your whole rights stems from how you appointed and what your conditions of appointment. Now we can overreach it. Now your case is not good because of the fact that when you appointed, it was you can see it might be a foreign action on a part of the engineer appointed you against posts that don't exist anymore. Under what consideration was it done? That has not been gone into. How does it not continue? That has not been gone into. Now the time comes for you at the fag end of your service life that this situation has come. Now you were not paid because of all these lapses that happened before. That now they find a fine day that appoints non-sanctioned post, no question of regularization, no question of. So that's the thing. The only thing you have to forego is that now the constitutional regularization also now be difficult for them. But you can sanction post, they'll be against from the date you were appointed against that post. But that 80 to 78 memorandum will apply. Ad hoc, 3F or ad hoc appointees appointed against sanctioned posts, they continued. Fine, regularization will continue for your purpose of your pension and your increments. You understand? It'll be counted. But in your case now, whether that even that memorandum will apply and also that's under the Meghalaya revision of pay rules or under the pension rules, that also will have to be examined. So there's many things. The things that because everything comes from the source of your employment. So we're just trying to, sort of, what to say? What do you want to show? Yes.
Just a sample of works that I've been working, Lordship.
Huh?
Just a sample of works that I've
Where's
been
that?
working.
Master rule?
No, Lordship. In my rejoinder, where
yes,
that I have just
we have given a lot of liberty.
That I have
I just
performed
put
my
a
duty.
detailed order in 2 pages. Yes.
That's on page 47, Lordship.
I want to encourage lawyers to argue, like it's thing.
Yes,
It's
Lordship,
good
that's
also.
what
Yes.
Page 47 onwards.
Page 47.
Yes, Lordship.
Your clients understand also. They've been given, sort of a benefit, which they're not entitled
Which
to.
is not entitled.
Because the thing is that now these posts should have gone through the district election committee. From the time you appointed, if the vacancies were there, they should have gone straight there for, then the first proper selection. Then you would have benefited also. But they were kept under the radar. There was never any request from the PWD you submitted for requisitioning that these posts are there. Nothing was there. There's nothing record, nothing you put here. It's all under the radar. Then one fine day, the whole thing collapses. Yes, page 47.
Yes, Lordship.
Of your annexure 9.
Of my rejoinder, Lordship. That's annexure 9, yeah. Onwards.
Annexure 9.
Annexure 9, also. These are only the
role.
sample of works that I've been doing, Lordship.
You're not paid for these ones?
No, Lordship.
This is dated when?
2023, Lordship.
Page?
Page 47, Lordship.
Yes, look at page 47. This is master rule.
Yes, Lordship. These are the lists that I am maintaining, Lordship.
Maintaining for whom?
Maintaining
For
the
master
lists,
workers?
Lordship. Yes, Lordship. in page 48 is the type copy, Your Lordship. In Jongsha areas, Makan areas, and also I'm maintaining, Your Lordship.
So if people are legally using your services as executive engineer, then we should direct pay from his pocket for the entire thing. It's been done in some cases, you know. Suppose they extract service from you, they should. How much will you pay per month?
Around 54 something.
Then let him pay from his pocket. Where will we?
The assistant executive engineer has given this.
Yes. Stop. Certain decisions have also been placed by the learned counsel with the petitioner. You give the list of books whereby parity in pay has been allowed by the courts. Stop. Next para. I've heard learned counsel with the parties. Stop. It is noted. It is noted from the materials that have been brought forward and not disputed that the initial appointment of the writ petitioner was against a post that had lapsed. Stop. The said post, if ever existed, was never put up before the District Selection Committee for filling of such vacancy. The writ petitioner was allowed from a date initial appointment, as observed earlier, before that. Initial appointment 31st July 2001. The petitioner was temporary as section assistant for a period of 3 months on an ad hoc basis. Stop. Which were subsequently extended. It is also noted that in a letter dated 37/2005, under the hand of the Joint Secretary to the Government of Meghalaya, the writ petitioner was allowed to continue and the post and the post, if any, was never informed to the District Selection Committee. This is 2005. This Edie Litton is the mother of this Hawa Manathan.
Yes.
This is really contrived.
His name was forwarded to the cabinet also wrongly or rightly by her only. Yes.
Not by
Yes,
the mother.
anyway, and I thought
Mother retired long time back.
yes.
No, mother's,
Yes.
she made the groundwork there.
Yes.
No.
There was a temporary as a section assistant for a period of 3 months on ad hoc basis. and a post, and the said post, if any, was not informed to the district selection committee, as is wont to be done in matters of regular selection. Stop. What is the age of this Hawa man?
46 now.
Yes, increments granted. And also. It transpired. The court knows, not courts, the appointments of the appointment of petitioner, however, initially being temporary, was not against any sanction post, and as such, there can be no question of being regularized at that stage, in view of the fact that, in view of the condition of appointment, and the fact that there was, and in view of the terms of appointment, and the non-existence of a post to which he could be accommodated against. Stop. As submitted by the learned AAG, MST Yangi, as the writ petitioner was appointed to a non-sanctioned post, and as this and as he was sanctioned post before the year 2007, the matter, he became eligible for regularization as per the decision of the cabinet on, where is the affidavit? On
15 March 2022.
We're really grappling around. Usually I don't take too long to grapple. Yes. 15 March 2022, when the government decided to approve regularization of ad hoc appointees subject to fulfillment of certain conditions. Stop. The court also has noted that with regard to temporary retention of other section assistants who were similarly appointed in 2001, a few of them, numbering 9 number, had accepted contractual appointment. Stop. The writ petitioner is situated today.
My lord, may I interrupt, lordship?
Yes.
Those employees, 9 of them, they were not recommended by the cabinet. They were not included in the cabinet.
Yes, what?
Okay.
Tom, no? I didn't see. I said the name.
They have accepted contractual employment.
Of section assistants, yes, so appointed similarly, yes. Yes. Had accepted contractual appointment, which was refused by the writ petitioners. Stop. 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 With the advent of the cabinet decision, the petitioner has got a second chance to have his service regularized. Now we are assuring regularization, right?
Yeah.
As per the statement of respondents. Stop. It is to be noted that at this stage that the appointment of the petitioner was irregular, not through a due selection process, and was allowed to continue as such for over 20 years without any without any orders. No, I'm getting lost. Things that no, it be problems lang biang. Nabas lang biang. To nabas lang mantan. It's been noted that the police were appointed regularly. Last I told the stage right. Was though not illegal, was irregularly made on a temporary basis as ad hoc section assistance. Stop. Further, it's also to be kept in mind that the same was against non-existent posts and the services were retained purely on extension orders passed by the concerned department. Stop. The authorization, therefore, in view of the decision of the Cabinet, though to the petitioner may seem inadequate, however, in the considered view of the court, will address the grievance to a large extent, considering the nature of his employment and the manner in which the same was made and continued. Stop. This court has noted from the letters appended to the writ petition that the manner of continuance of service of the writ petitioner is also highly irregular. But it is too late in the day to take any corrective measures. Stop. On the prayer of the writ petitioner for concession of back wages, will deny it. The same is rejected, and the respondents are to take up the materialization of the writ petitioner within a period of
2 months.
to complete the process in a period of 2 months. Yes, I'll correct the order later on.
The other item is also the same, Lordship, similar.
You can't. This is a totally illegal
Totally
appointment.
illegal thing.
It takes us back.
Rightly or wrongly,
This
their
happen
names.
in many, especially duties happen. We have these exam engineers, they appoint people, and this is a problem that.
Mostly in this department, Your Lordship, and rightly or wrongly, their names were forwarded to the Cabinet. Otherwise, we would not have agreed.
Obliged.
Much obliged, Your Lordship.
Mr. Jha, we'll close this matter. Dr. Mosiga's closer matters.
This can take some other demand.
He's waited for so long.
No problem. Not an issue.
But I've raised the issue of jurisdiction also here.
Oh yes, it's for armed forces.
Armed forces. No, madam. Here what happened, my lord?
It's a paramilitary Assam rifle.
The petitioner was on deputation to NDRF, my lord.
Oh yes. Where the thing
in Punjab, my lord.
Yes.
The penalty has been imposed by NDRF in Punjab.
By the Assam rifle?
No, by NDRF.
In Punjab, they pass all the gun rifles. Okay, list on because the list matter on so and so. It's a political order. I don't want to pass any stuff. Very difficult, totally illegal appointment. Anyway, mother's love.